पूरा त्रिमूर्ति आगे बैठ लेगा.
Item, we are filing our
Today. Okay. So it has to be adjourned then?
yes, my lord.
Okay, who is for the petitioner?
Yeah.
You are there. Okay. Both sides. By way of an affidavit.
Yes.
Today. Full stop. Accordingly, matter stands adjourned today. List after
Lordship, after two weeks.
2
Lordship.
weeks. Okay.
Obligation.
Service complete paper bill.
This is the There's no representation from the applicant and the learned additional public prosecutor. Oh, you're there. Okay. This is, how Mr. Gita as the applicant was convicted, amongst others, under Section 6 of the POCSO Act, which is there in the ground floor. We can make it available for you.
No, not anyway, but I know for Mr. Dilip Muzumdar will appear. Mr. Deori has informed me. Mr. Deori is very much available.
Mr.
Exposing.
That is all.
Okay.
He is very much available.
Pardon, sir.
Your name?
Likharuki.
Please write it down. Huh?
Okay.
The counsel for the applicant.
IE was for leave. In writ appeal, we are the respondent. Interlocutory application we filed seeking leave.
Yes. Yes, sir.
They want to file objection against our affidavit, possibly stating that demarcation is not there. Be that as it may, whatever. Yes, they have done it. That's the whole issue. Their land is not there. Government says so.
Senior counsel assisted by
Not, Mr. Kamal Saxena is there.
Case
Lord.
Saxena, counsel for the applicant. As well as Mr.
Likaruki.
Learned counsel for the opposite party. Number? Your opposite party number? For the opposite
They are the
parties.
appellant. They are the writ appellant.
So opposite parties number 1 to 32. 1 to 32. Next para. Also heard your
P. Sangeeta, Your Lordship,
learned government advocate referring for respondent number.
4 and 6.
No, opposite party number 34. Here you will be
6 in IA.
IA 34, 36. Union of India was appearing. Mr. M. Kato, learned DSGI for respondent number opposite party number 33. Next, the learned counsel for the opposite parties number 1 to 32. Place for is granted 3 weeks time to file objection affidavit in this matter. List after 3 weeks.
But Lord, IA may be disposed of because IA is for seeking leave to introduce the affidavit.
For that they want to file an objection. We are allowing it.
Not against IA, against our affidavit, they want to file. IA is for leave. Leave to introduce affidavit, bringing on record subsequent developments.
But he's paying for objection here.
I don't know.
What do you want?
We are filing against IA by respondent number 2 and 3.
It's not IA, I know. But anyway, but if this is the instruction,
No, I don't know.
I'm quite amazed.
Huh.
Lordship knows very well against IA, there can't be any affidavit. Affidavit is against the,
No, he wants to file an objection here. Let him do it.
anyway, let them whatever they want to file.
Young people must get a chance. Number 7. Yeah, it is very good.
Hello, yes. हाँ जरूर हो गया ये सब कितना लिखा हुआ वेरी My lord, may kindly flip to page 13 and 14 for a moment. Beloved witnesses and all, let me try to place major technical flaws in convicting the accused here, my lord. We have page 13, exhibit 5. This, to my understanding, is absolutely.
First of all, you come to the evidence and then the appreciation, then we'll come to know about the fault.
well,
Otherwise,
just-
we start from
No,
backside.
just as a cursory point, I'm putting on this, on a technical aspect, my lord. This is absolutely a non-compliance of section 38(1) of the POSCO Act, read with Rule 5, and as well as section 119 of the Indian Evidence Act. This aspect, because while recording 164 statement of the victim, the mother was the interpreter. Definitely, that means definitely there was a violation of section 118 of the Evidence Act also. The child evidence is vulnerable, can be a tutor one. No, let us.
The child is a special child,
Yes.
correct? There's no evidence on record to show that this special child
Correct.
had gone to a formal training. Now, let me ask you a simple question. My examples are always horrible, but you'll have to tolerate it. Now, I have a friend of mine who has a dog. Now, this friend, whenever he does some action, the dog retaliates. Correct, as if he's a human being. So when my friend asks anything to this dog, he can respond to it. So I'm just giving an example. So if a child is not having a formal education in a special school, except for the members of the family, nobody else will be able to communicate. So you'll have to demonstrate that in the trial court. You took an exception to this, and still the court. You see, even if you disregard that.
That is what my
that
lord is
statement.
referring to section 145,
No, I'm not referring to anything right now.
Evidence
I'm
Act.
just giving a very horrible example. And then I'm trying to compare it that a member of the family, you'll have to also demonstrate from their cross-examination of the mother that you introduce something which shows that there was some previous animosity, or there is some reason to give a doctored statement. What you call, please come to this, the
13 and
page
14.
13, 14.
Milord, may I make a request, Milord?
Yes.
Yesterday, I called up my two friends after landing from Delhi, Milord. So I said, I may not be well prepared for tomorrow. Please don't insist if I seek an adjournment, Milord. Milord, next week, then still I remember because like
Because this girl
One
child,
particular-
the minor, the victim,
Milord.
is 4.5 years old. She can speak only in vernacular Adi language only. And now, you see, under the POCSO Act, there is a requirement, but I am sorry to say that nowhere in the country those facilities are available. There's a requirement under the POCSO Act that every district magistrate shall have a list of interpreters.
Rule
Correct. But I can tell you, the specially trained people, for example, deaf and dumb, even in Guwahati, it is not available. And people who are there, They don't want to offer their names to come to court as a witness because of the harrowing experience some people face in the courtroom. We, as a counsel, we may do so many things, but when it comes to cross-examining a witness, we are not that polite. I include myself into it. We may not be so polite. So therefore, people are not readily giving their names, offering their names to be an interpreter for a specially able child, for a child who has got language barrier.
Correct. But
Correct.
according to rule book, Milord, they should prepare a list of interpreter. And
Okay.
here is a case,
You-
Milord,
you
where
see,
mother is the
let me tell you-
complainant.
Let me tell you.
Yes, yes.
Again, one of my horrible examples.
Correct.
Now, without taking your confidence, without having a word with you, introduce your name in a panel of legal aid counsel. Correct. Now, you may take it in a good gesture that I've been appointed as an amicus curiae by the court. You may also take an exception that without my consent, how could my name be entered in the list? I did not offer my name. So why my name was entered into a list over there, I take an offense of that. And if you take an offense, I am the one who is guilty. Because I ought to have consulted and given your name in the first place. So you see, everything has is a give and take, and therefore the list, I'm telling you because I have dealt with this issue. Not only here, I've dealt with this issue even in Kohima bench. I've dealt with this issue in principal seat. And we have discussed these matters in the conference held by the Supreme Court of India. It happened only about a month and a half back. Because nationally we don't have the name of list of interpreters for any matter altogether. Supposing now here, today, let's say an NSCN activities arrested. Now, he's to be produced before a magistrate within the time allowed. Now, he may be speaking a dialect which is not normally known to people here. Now, please tell me, if somebody is to be produced who doesn't know the language into court within 24 hours of his arrest, and he comes and says that, well, I was produced before a court, but nobody told my language, I didn't understand what is happening there. So my fundamental right is violated. We don't have an answer to it.
I can only say, Milord, conflict of law with human conditions.
We come to it.
That is
We are
always
open to it.
possible.
We are open to it.
Conflict of law with human conditions. Human conditions, Milord, invariable the customs, the ethnicity, the language, the dress, and all those things comes.
It is okay.
So therefore,
Take into
Milord,
consideration your
anyway, Milord, I may kindly be accommodated for a week. I have not come prepared as well. Because, Milord, I will Section 6 of Evidence Act. Reverse what that is. 106. Reverse murder. That reverse burden will also come. The theory of reverse burden that I'm supposed to press into a lateral stage 106. Yes, I'm falling back. Amicus number. So,
आगे कोई स्टेट लो से
after a week, sir. After a week. Yes. Grateful.
But before starting at item 8, before starting item 8, my lord. I'll just make a mention. Malota. Inquiry report as directed by order dated. Inquiry report. As that. This one.
Please, Lordship. The last occasion, the respondent number 2 by filing intimated this, they made it considering the case of the respondent number 3, 4 and 5 from the date of availability of vacancy against the promotional quota Lordship. And they prepared a list number 1 to 3 on the of the state affidavit Lordship, saying it as a promotional quota Lordship. And accepting this Lordship, this honorable court Lordship, in the last occasion Lordship, inclined to dispose of the petition appeal Lordship. But we have a clear instruction from our client Lordship. The averment made in this paragraph Lordship, perhaps position which they are showing Lordship, it's not a promotional quota, but there is a direct quota is also there and temporary quota is also there Lordship. And we have a clear instruction of our client Lordship to that effect Lordship. And if your Lordship permits, they showing it. But in the there is a specific averment. The said quota is a promotional quota, but there is one is not promotional Lordship. It was meant for the direct. No.
My lord, the private respondents are the beneficiary. In fact, they are happy with this, my lord. The present appellants, those who are the direct recruiters, they are not happy with this. At page 7, they are unhappy with serial number 3. That this is on promotion of Sri Itum Naso, so and so. At my affidavit, my lord, at page 6. There is a chart, my lord. Page 6.
Page 6.
Of affidavit in affidavit by the respondent number 2.
Respondent number 2.
Yes, madam.
What is the date of your appointment?
Our appointment Lordship. There are 40 numbers of applicant Lordship in this case. 2011 to 2019. 2009 to 2019. At page 7 of the 2019.
Whoever is there in 2009 to 2010, naturally will be senior to this.
But-
From 2011 onwards, they are promoted against promotional quota. So between promotee and direct promotee will be senior.
There are other applicant lordship who were appointed from the 2022-11, 2012. But regarding three, we have, there will be no hamper in recasting the seniority laws. But if we accepted their proposition lordship, the others will be affected. Lordship. Those who were appointed after 2012.
However, they are not before us.
Before your lordship, is a applicant here.
They are not holding.
14 applicants are there.
No. The appellants that are there.
Hmm.
What they are saying, my lord, this serial number 3, Itum Naso, he is shown to be promoted, but this on promotion of one engineer, Lord Tanyo. But this is a direct repeat, what they are saying. So
That will be immaterial. If that quota between direct input and the promotee is maintained, how can you have any difference? Other two, you are agreeing. Serial number 1, Moni Tatu and Joba Loya, you are agreeing.
No, lordship. Regarding
You
serial.
see, in this, we have not been able to follow you because of the fact that the column number 4 is post fallen vacant in promotion quota. So they are saying that all these three are promotion quota. Now, how do you presume that this is not a present promotional quota?
it is, they are saying that this is a direct equity and
Serial number 3 is a direct equity lordship.
You can look at them. You are coming by way of direct. So, no, you go post Khali. Direct promotion.
It would also, and there is a apprehension that lordship, I have prepared a chart lordship, page number, kindly come to the page number 7 of the appeal memo. The date of our appointments, lordship, there are 14 numbers of applicants here, lordship. Regarding 1 to 3, if they place as proposed selection, we have no.
Mr. Ratan, how many, this cadre is of how many posts? How many posts are there for this cadre?
70 sanction posts.
77,
70.
70,
70.
What is the distribution?
50%, 50%.
50%.
50,
So
50.
that means
Direct
30
recruit,
35 is direct and
35
35 is promotees.
promotees.
We have a gradation list, common gradation list.
My lord, that's why I've asked the department to exercise. How many are in the at present occupying the direct recruit quota, and how many are in the promotee quota? They are confused in this, my lord.
No, just a moment. They can't be confused. If the department is confused, then they should wind up the department, hand it over to somebody else, outsource it. Outsource the management of the department to somebody else.
Exactly,
Give it
my
to
lord.
private parties. If they are confused with this, you see, we are anxious of only one thing. Number one, we pass an order and then somebody comes and says that I am affected. So that should not happen. So in fact, we don't understand if there is a gradation list, if the vacancy posts are identified. What is the difficulty in telling us that this is the 50% promotion quota, and this is direct recruitment? And this, yes, my brother is absolutely right. In your affidavit, you come to your chart, page 6, come to your chart. Now just show us how do you identify this post fallen vacant on promotion quota. Just show us how do you, what is the material to arrive at this? End of the matter.
Exactly, my lord. That's why if the writ appellants are not, my lord, may dispose of the matter, saying that the department
You see, disposal is
exercise
something. You see,
to find out the
no, Mr. Ratan.
correct vacancy position.
No, Mr. Ratan. When we dispose of, then the intention is that the parties should know where they stand. The orders would not be subject to further adjudicatory process. We won't let our order be examined by some secretary level people saying that you do that exercise. The order which we intend to pass must be a speaking order and must convey the actual order of the court. No further exercise. We won't allow anybody else to sit in appeal over our orders. That's one. Second, we are reiterating that in the order there must be a clarity that no third party would be affected by the order. So therefore, if somebody says that it is incorrect, the appellant comes and says that the projection is incorrect. So just produce the gradation list from there only, where it stands, or from which you have page 6 chart.
Radhan, you come to para 17 of your that.
Para?
Para 17.
17, page 5.
Yes, my lord.
So waiting. The PHN have prepared a proposal for contracting center which shall be contracted coming for retrospective promotion of the private respondent from the date of availability of vacancy against promotion quota and not from the date of their allotment. So you know.
No, my lord. We have only this affidavit. How?
You have determined the promotional quota.
Yes.
How you have determined it? That few lines.
Committee which have convened for the promotion of private vacancies against promotion quota and not from the date of their error promotions. We have already done that exercise.
Yes, my lord. That's why department has done. Now the appellant, they are again questioning this.
They are not questioning it. The order, they are just saying that our order is the implementable order. If you don't have, he says that in that chart, those are direct recruiting. Therefore, a direct recruiting do not have given placement in the promotional quota.
My lord, in that even let them file an objection to this, so showing that this is a.
Required. They just put some, they are
Para 17.
End of the matter.
Yes, my lord.
Can't say that without.
I will call for the records, my lord, in that event.
Para 17. That's all.
Yes, my lord. How they have arrived, my lord.
That we have 70 people and we don't know who is under which head. Yes, that's a brilliant. In fact, if you don't have data, you can disclose that also. If we don't have data.
In fact, I believe they have still not exercised it properly, my lord. What I believe.
Then he's right.
That's why, my lord. The contention that this is a direct recruit quota.
Then there's something more serious. You see, by the virtue of office you are holding as an assistant police general, you are also the law officer of the state. Because this lawlessness can be accepted as a part of your submission.
They have understood, my lord, how to maintain the vacancy position, 50%, 50%. But they are not able to find out when the actual vacancy arose, my lord. They are still confused.
Get those data. We will try if required.
They are still confused how to.
You just need to have a good statistician. Correct. One, and one man with 70 people, you give him 2 days of free time. Along with one statistician, he'll be able to do it. You know, when we were in matriculation, in metric examinations, they give seat allotments. One will be here, second will be here, third will be there in a room. How many tables, how many chairs, how many students would give the examination? How many schools are required? How many rooms are required? How many invigilators are required? In my time, about 1.5 to 2 lakh students used to give matriculation examination. 1.5, I think, examination were given. You know how many people were engaged to this? Only one man, Mr. Das. Mr. MC, I think PK Das, MC Das,
Board of Secretary.
Board of Secondary Education Assam.
Secretary.
उस दिन इंस्ट्रक्शन देगा बोला देखो जब ये may I suggest, my lord, since there is an objection by the appellant with regard to this chart, my lord may pass an order directing the authorities to reconsider this how the records, my lord.
As well as, full stop. If any gradation list is available, current gradation list is available, a copy of the same we also produced. Day after tomorrow,
Yes, ma'am.
list on.
Can it be?
30.
Can it be at the?
No, after that, we'll fix a date of hearing. We ask somebody to be here. We just examine this and then we will adjourn it.
Copy of this order may be furnished.
Oh, okay. The next paragraph.
Available देंगे.
The learned additional advocate general is permitted to send a downloaded copy of this order to the respondent authorities to obtain the records.
Always, ma'am.
Right, right.
Still, Mr. Anshuman is having personal difficulty and going to Calcutta for some medical purpose. So therefore, matter may be fixed after 4 weeks, as consented by the other party also. Madam.
Okay. Item 25.
25 months.
All sides are represented. On the prayer made by Mr. M. Kato, counsel for the petitioner, matter stands adjourned today, just after 4 weeks.
Madam. Deep level.
May I, Your Lordship? I beg to mention item number 23 and 24, Your Lordship.
Yes,
This matter will be listed after 2 weeks.
23, 24.
24 June.
He's here.
My lord, see that, my lord, we have received the paragraphs copy, but my lord is under typing.
Okay.
And so for my lord, item number 23 is concerned, my lord, this might take some longer time.
How much time? 3?
My lord, could it be fixed towards the end of June, my lord?
End of June, my lord, yes, my lord.
Okay. Item 23, 24. All sides are represented. On the prayer made by learned additional advocate general. 3 weeks time is granted to file affidavit in opposition in the matter. Next para list on, give last date in the last week of June.
But if it is not inconvenient, it will be on 24th June, my lord.
24. Yes.
Monday.
Yes, no, no. Just I forgot to ask Nava. Okay, list on 24/6/2024.
Your Lordship, I beg to mention item number 4, Your Lordship.
Item
4. This matter may be listed after 1 week, Your Lordship.
there is something in this matter. Just a moment. 4. Why are you wanting an adjournment, Ms. Mandul?
Yeah, actually, Your Lordship, our senior government advocate, Estapin, is appearing, so he instructed me to adjourn this matter.
Okay. What is the representative on the prayer made by the government advocate? List after week as performed.
And also, Your Lordship, item number 8, Your Lordship. In this, Your Lordship, our department has already filed their affidavit. We are yet to file affidavit, Your Lordship. We have received wrong paragraphs reply from the power department. So Your Lordship, we need some more time, Your Lordship. In item number 8,
8. You want to file affidavit
yes, Your Lordship.
for,
Respondent number 2, 3, and 4, Your Lordship.
okay, which department?
For Your Lordship.
Deputy Commissioner.
Deputy Commissioner.
Deputy Commissioner, okay. Item 8, okay. Both sides are represented. On the prayer made by the government advocate, matters is adjourned today to enable respondent number.
Respondent number,
Who will file affidavit?
State Government, Your Lordship, Deputy Commissioner.
To enable the state respondents to file affidavit in opposition to the matter. List after 2 weeks.
3 weeks, Your Lordship.
List after 3 weeks.
Obvious, Your Lordship.
An interim order is there, no?
There's no interim.
May Lordship. Lordship, I would like to mention item number 10, Lordship. I may be allowed to file regional, Lordship. And I taken the consent from other side, Lordship. Item number 10, Lordship.
10.
Yes, Lordship.
All sides are represented. List after 2 weeks just to enable the petitioner to file affidavit in opposition to the matter.
No, affidavit in reply, Lordship.
Oh, sir, affidavit in reply in the matter.
Yes, Lordship. 3 weeks, Lordship.
3 weeks, okay, 3 weeks.
Much allowed.
Oh, may I please, my lord? I beg to mention item number 29. Here. My lord, I have taken the consent from the opposite party. Kindly fix that may be given.
You have a petitioner.
I'm for the respondent.
For a petitioner. On behalf of yet again.
Both sides are represented on the.
My lord, it's my humble request. Kindly fix that may be given. Fix that may be given.
Counsel for the private respondent. Matter stands adjourned today. List on
27 June.
June 27.
June 27. You want so such a long date.
My lord, the matter is fixed for final disposal. Therefore, maybe
27/6. Okay.
There's an interim order in this case. Kindly
Interim order
repeat
passed
it.
study stands extended to the next posting.
my lord, I'm mentioning one more item number. Item 11. Here I am for the petitioner. My lord, as per the last order, respondent number 2 needs to file the affidavit. I have taken the consent from him. Next date may be fixed for admission.
Yeah, Lordship. Lordship, I'm for respondent number 2. And today we are filing our affidavit in opposition.
You're filing it.
Lordship,
When?
today itself.
Okay. All sides are represented. The counsel for respondent number 2 submits that he will be filing an affidavit in opposition in course of the day. Full stop. Accordingly, but list after 2 weeks.
Yes.
Okay. Yes.
Mr. Please.
My Your Lordship, I would like to mention unlisted matter. This is a MATE application 0123 on behalf of the DMAD, sir. He told me that due to some hearing of this case, Your Honor, may fix this matter on the 30th of this month, if possible, my lord.
You want to make a mention?
Yes, mention unlisted matter to fix this matter on 30th of this month, if possible, my lord.
P0 is, no, make it tomorrow, not 30.
This is not listed matter, Your Honor, unlisted matter. This is
Make
unlisted.
it tomorrow. Make it tomorrow. Tomorrow is 29th, not on 30.
Your Honor, no, Your Honor, because the instruction given by the DMAD, sir, is specific in the 30th of this month date.
No, 30 is a hearing day. I'm not giving this applications on those days.
Okay, my lord.
I have to dispose of matters. I have to take up hearing.
Okay.
Ask him to come tomorrow. We are committing it.
The same 30th of this month, both
No,
of the.
no, not on 30. 30, I'm not fixing any matter.
Okay,
It's a
my
Thursday, we try to take up some hearing matters on that day.
not allow, Your Honor.
I'll allow it for tomorrow, not for 30.
It's ready for tomorrow, not for 30.
But my lord, the Medis are not come to the tomorrow, only
Then
30.
Make it next week.
Okay, my
Make it next week, not this week. Then.
okay, much obliged, my lord.
Kindly indulgence to item 26. 26, item 26. With my brother Pangil, we have difficulty today. More kindly,
Item 6.
26.
Oh, 26.
Yes. On 11th, madam.
Is it 2016 matter?
Yes, yes, my lord. I am, because this has been listing very frequently, but for paucity of time, it could not be taken up. So matter ends up adjourning, so we decided for 11th.
Okay. All sides are represented. As agreed to by all sides.
11th. 11/6.
11/6/2024.
Interim to continue, my lord.
Something out of this transaction date, evidently to listening.
Right.
My lord, I may be allowed to mention item number 15. This morning I have telephonically informed by the counsel for the petitioner, Mr. M. Nibo, that he is not doing well. So this matter may be listed after 3 weeks.
Okay. Both sides are represented on the prayer made by counsel for the petitioner. This
No,
will
not,
be
not
weeks.
petitioner. I am for the respondent. I am for the department.
Item 15.
Yes.
Item 15, you asked
Yes,
for
yes.
adjournment.
Item number 15. Counsel for the petition, Mr. M. Nibo, he is not doing well. So he has requested me to take
So
adjournment.
What order did I pass? What was the order which I dictated? What is the order? You heard me.
Okay.
You objected to it.
No,
What
no,
is the
no.
order which I passed?
Apology, my lord. My lord, on request.
List after 3 weeks. Okay. Please hear us first, then objecting. Correct.
Sorry.
If you
Sir.
don't hear us, then you don't have knowing what order is being passed.
Apology.
My lord, I beg to mention item number 6. The matter will be listed on 10
Item
June.
number
6. Item number 6.
6.
My lord, the matter on 10 June.
Okay, all sides are represented. You are for petitioner.
Petitioner.
Okay, the prayer made by counsel for the petitioner, list on 10/6/2024.
I'm for the state lordship in this matter.
Also,
Lordship. Okay.
No, yeah, Lordship, I like to mention item number 19 on behalf of Tabatagum, who is the standing counsel for education department.
19.
19. 19.
19.
Yes, Your Honor. I've taken consent from the other parties. This matter may be fixed on 24 June.
Yes. When do you want?
24 June.
24 June.
Yes, Your Honor.
It's an interim order in my favor. Okay, all sides are represented on the prayer made by learned counsel for respondent number.
All respondent number. All respondent.
For the respondents, the matter stands adjourned today. The interim order passed earlier stand next list on 24/6/2024.
Deep relation.
Lordship, I beg to mention item number 7 on behalf of the counsel for the petitioner. I pray your lordship to fix this matter after 2 weeks. Yes, lordship.
Okay, all sides are represented counsel for the petitioner. List after 2 weeks.
Your lordship, I would also like to mention item number 9.
Item number
9.
9. Same order.
Much obliged.
Well, Lordship, I beg to mention item number 14. My lord, in this matter, I'm yet to file counter affidavit. Matter may be listed after 3 weeks.
I didn't get you. Please repeat again.
I'm yet to file counter affidavit.
To borrow pen? You want to borrow my pen to write?
I've taken consent from
If
that.
not filed, then it's okay. But when you are filing it, give us a date when you are filing it.
My lord, respondent number 4 is unable to come to swear this affidavit.
So you get him arrested and brought him here. You're not getting assistance from him. We'll bring him tomorrow. No, I can put him into arrest and bring him here. At 226, I've got powers because he's interfering with the administration of justice. I will take up a suo motu contempt, get him arrested, brought him here. Just to tell us, will I record your statement?
My lord, last chance.
No. So don't take adjournments for granted. 2022 matters. Who is for whom you are representing?
Respondent number 4.
Respondent number?
4.
4.
Small.
All sides are represented. Prayer for adjournment is made on behalf of respondent number 4. First of the prayer for adjournment is reluctantly allowed. First of the respondent number 4 put to note. His petition is filed within 10 days. The respondent number 4 shall forfeit his right to file any affidavit in opposition thereafter. Full stop. List on, give up 10 days. 12/6/2024. So you forfeit your right after that.
Okay. My lord, one more matter. My lord, I've mentioned item number 28.
28.
My lord, in this matter, the court is yet to appoint amicus curiae. 28.
Let us see, item 28. 28.
Your Lordship, here in this case, the appellant was directed to take steps upon respondent number 2 because it's a pertaining to POCSO matter, Your Lordship.
It is duly served.
Yes, Your Lordship, in that case, Your Lordship, let them give an opportunity. Otherwise, on next date, Your Lordship may please to appoint a legal aid counsel.
We will do it now. If they appear, we'll revoke that.
Okay, Your Lordship. May appoint the legal aid counsel and fix it.
From that list, give a name of legal counsel. The appellant and the respondent number 1 are represented. None appears on call for respondent service of notice. Next paragraph, as the convicted from amount from under Section 8 of the POCSO Act. Am I security to represent respondent number 2? Stop. Paperwork is ready?
Yes, paperwork is ready, Your Lordship.
Okay, the registry shall also provide a copy of paperwork to the learned legal aid counsel for respondent number 2. Next paragraph. This is the matter for hearing after 2 weeks on a date to be fixed by the office. Yes. Yes. From that list, give a name. Might security. From that list, choose one person. Appoint. Yes. Next.
Deeply obliged, Your Lordship.
My Lordship, I would like to mention item number 16.
16.
Yes. In this matter, service awaited. So we may be given some more time to file a fresh report to respondent number 5.
The except for respondent number 5, all are represented. Next para, the petitioner shall take fresh steps within 2 days for service of notice on respondent number 5 by registered post with AD. The learned counsel for the shall collect the postal receipt number from the registry and submit postal track code prior to the next date of listing. Next para, notice is made returnable on, give a date after 5 weeks. On Spencer, list on Spencer. Yes,
My lordship, lordship, I would like to mention item number 27, lordship.
27.
Yes, lordship. This may maybe after 2 weeks, lordship. I'm taking the consent from the other side, lordship. Item number 27, lord.
27.
Yes, lordship. Item number 27, lordship.
Okay, just after 2 weeks, as paid for by the counsel for the appellant.
Much obliged.
Your Lordship, may I mention item number 12? In that matter, I need to file rejoinder. So I need some 2 weeks time. I have the consent of the other party.
List after 2 weeks, so enable the petitioner to file rejoinder affidavit in the matter.
On this.
Yes,
This writ petition is for enforcement of terms and conditions of NIT, my lord. Now, the fact of the case is that, my lord, the respondent authorities, my lord, has issued an notice inviting e-tender dated 26/7/2023 for development of distribution infrastructure in Lower Subansiri, Lower Siang district of Arunachal Pradesh. Now, pursuant to that, my lord, I have purchased the NIT documents, my lord. Well, the NIT is at page 58. Annexure 3. Now, the SBD, my lord, is starts from page 64, my lord. My case is that, my lord, in the entire NIT and in the SBD, my lord, there has been no clause for maximum and minimum, my lord, quoting of price, my lord.
just a moment. I did not get the date on which you submitted your tender. Where is the date?
NIT on 29/2023, my lord.
20.
20/9/23.
Where is that statement?
That statement, my lord, will be at page, my lord, paragraph 6, my lord, page 18.
Yes.
Yes, my lord. Now, my lord, generally what's happened, my lord, there in the NIT, my lord, there is some clause, or in the SPT, or that is my case, my lord. May I, my lord, may I? Now, my lord, this is the for date, my lord, for the query made by your lordship, my lord. I will take your lordship to, my lord, page 93, my lord, of the writ petition. This is the SBT, my lord.
You can, you have instructions whether it was uploaded in the website?
This was circulated, my lord.
No, question, I don't know about circulation. Did you upload it in the website? You call your officer and get the instruction. We'll issue notice here. Solution and interest. Your
Yes,
name?
Lordship. Your Lordship,
Your name?
E. Payang, Your Lordship. E. Payang.
E. Payang,
Payang, yes, Your Lordship.
Land Council for the.
In fact, my lord, the very order of the division bench which they are relying, there is an SLP pending and there is a stay.
You issue a notice, we
Yes,
have
ma'am.
to, because solution and interest is part of the compensation scheme.
Yes, ma'am.
Council for the, Council for the petitioner. Mr. N. Ratan, Additional Advocate General,
For 1 and 3.
for the respondent numbers 1 and 2.
1 and 3.
1 and 3, and Mr. M. Kato, learned DSGI
For respondent number 5.
for respondent number 5. And land management 2, Mr. Kamdu,
And Mr. Kamdu.
Mr. D. Kamdu, standing counsel for respondent number 2. Agreed by the non-payment of solution and interest in respect of the land of the petitioner, land of the petitioners acquired. Some of the present writ petition has been filed under Article 226 of the Constitution of India. Next paragraph. The Learned Additional Advocate General for the state has submitted that in this case, the petitioners are relying on the judgment dated 12/9/2022 passed by the division bench of this court in WA 15 of 2022. And in this regard, it is submitted that an SLP against the said order is pending adjudication before the Supreme Court of India. Next part. Be that as it may, issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned state and departmental council, state departmental council as well as the learned DSGI within 2 days. Next part, list on list after 4 weeks.
Much obliged.
May I plead, my lord? My lord, this matter related to land acquisitions for hydroelectric power project for Tato 2. My lord, in this case, land was acquired.
Mr. Navam, if there's an award, why the petitioner is not aware of the award?
My lord, that is quite strange, my lord.
Yes,
Definitely, my lord, if compensation is to be paid, there has to be award, my lord.
yes.
Yeah, without award, there can be compensation.
He's coming to court only to know the award.
We have filed RTA, even then they have not provided. We have RTA before the deputy commissioner. We have filed RTA before the NAPCO, who is the project proponent. They say that it cannot be applied, and it cannot be issued under RTA under section, they say this under section 8(1) subclause J. It is something personal individual matter. That's what.
No,
they say.
is your land acquired? No.
Yes, yes, my lord.
Where is that statement?
Yes, my lord. Here, my lord, we are in the project affected families, my lord. May I just take to the paragraph 2? We have mentioned where we are. Paragraph 2, my lord. Petitioners among the project affected families for construction Tattoo Hydro Power Project by NEPCO. Their names are reflected in the serial number, my lord, 30.
Okay.
30, 2, 51, 3, 6, 31, 90, 17, 40, 23, 49, and 40. My lord, the project affected families lists are in Annexure 1. Annexure 1 is it start from page 33, my lord.
It's up to 96.
Page 30.
Heard Mr. S. Mohan, counsel for the petitioners. By referring to Annexure 1 of this writ petition, it is projected that the petitioners, whose name appear in serial number 30, 2, 51, 3, 6, 31, 90, 17, 40, 23, 49, and 14 of the said list, are projected affected families for construction of TATO Roman 2 hydroelectric project being set up by NIPCO. The grievance of the petitioners is that they have not been provided with the award, with the copy of the award. And or bill or any other document from which they can know the quantum of compensation assessed against their land. In this writ petition, it is projected that the petitioners had also submitted RTI application dated 29/9/2023 before the circle officer. You submitted before whom?
DLR submitted.
Before the DLR.
So.
And SO, Shi Yomi district, Tato. But the reply, RTA reply was refused. Correct?
Yes, my lord. Saying that the originals are not available.
It was refused on the ground that the original award is not available. Accordingly, this writ petition has been filed under Article 226 of the Constitution of India. Next, issue notice, returnable in 4 weeks.
My lord, I am for 145.
Nawam Bennett, Additional Advocate General. Through
Respond number 145.
through his assisting counsel, Mr. No, your assisting counsel, Ms. Pango.
P. Pango, my
Ms.
lord.
P. Pango accepts notice on behalf of respondent numbers
1, 4, and 5.
1, 4, and 5.
Yes.
Mr. Your name. Yes. L. Tadam, Learned Counsel. Accepts notice on behalf of Mr. D. Kamruk, Standing Counsel for the Land Management Department, representing respondent numbers 2 and 3. Full stop. Accordingly, issuance of formal notice on the appearing respondents is dispensed with. Full stop. However, comma, requisite extra copies of the writ petition be served on the learned state and departmental counsel within 2 days. Next paragraph, the petitioner shall take steps. I don't know, your cost is wrong. Chairman can't be a respondent. He can be a supporting respondent, but NIPCO is not a party here.
Respondent
You're
number
not
6,
making an
Malad.
employer a party, you're making a managing director. Managing director is not to respond.
My lord, NAPCO is performer party, my lord. Main party is the state.
But why chairman? Chairman does not come to contest the matter.
Next, we will.
Order 32 CBC says the company must be,
Yes.
without making a company, how can you call the managing director? Chairman?
Chairman come managing director is, my lord, in fact.
No. Company must be represented. If the company is not here, what can the chairman do? Improper party.
Generally, Malad, company represent
Company
represent
represented by
either by the
chairman.
director or chairman, Malad.
Yes,
Yeah.
has to be. So having noted that the cost title of the respondent number 6 is defective, as the company is not a respondent, on the prayer made by learned counsel for the petitioner, he is permitted to make necessary correction in the cost title in respect of respondent number 6 by submitting a freshly typed cost title to the registry within 2 days. On receipt of the amended cost title for respondent number 6, the registry shall make it a part of record as page number 11, and the present page 11 be striked out and retained in record as page 11 within bracket A. Next paragraph. Pending amendment of cost title in respect of respondent number 6. I issue notice to the respondent number 6 returnable in 4 weeks. The petitioner shall take steps within 3 working days for service of notice on respondent number 6 by registered post with AD. Next paragraph. The pendency of this writ petition shall not be a bar for the Deputy Commissioner, Tato, the Deputy Commissioner, Shi Yomi District, Tato, to make an inquiry as to why the copy of award and or document relating to compensation assessed in respect of the petitioners has not been provided to them. And to release such information to the petitioner. Next paragraph. The petitioners are permitted to serve a certified copy of the order before the respondent number 4. Next paragraph. List after 4 weeks.
My lord, just may submit that. In fact, we have filed a RTA application and then we went.
Against RTI, you'll have to go in RTI appeal. RTI, we are not entertaining. I've given a direction. If you want, you can recall that direction.
Otherwise, my lord, I will pray that our representation is pending before Deputy Commissioner. That can be also.
I am not disposing of repetitions like that. Disposal of representation is something I'm not doing.
Because they have disbursed.
You want me to recall the order? I have asked them to give you a copy. You want me to recall that order? Okay,
No, my lord.
is recalled.
That
Then we are giving a direction and then you want to argue against the matter. No. I'm not the representation disposal judge.
okay, that.
If I am here, I will adjudicate. If I do that disposal representation, I can dispose of 100 cases a day. Why all these 10 matters and then spend my time?
Like that. Like.
Item? Yes.
My lord, may I, my lord? Fact of the case is that, my lord, this petitioners, my lord, are the landowners, my lord, of area located at Turung area. So, my lord, since there was some rampant.
No, please tell us.
Yes.
Under the Civil Courts Act, against the Kebang decision, you can go and file an
My
appeal.
contention is that, my lord, this is a report, my lord. Whether report is appealable, my lord. This is a report, my lord. May I please come to, I don't, in my writ petition, it is not a proper
Please.
document, but may I come to affidavit in opposition of respondent number 3 to 11, my lord. Page 20, my lord. This is the report, my lord.
No, you have filed a writ petition and now you are questioning whether the report appeal can be filed.
My lord, yes, this is the report, my lord. Whether
Which page?
page 20 of affidavit in opposition filed by respondent number 3 to 11, my lord. My lord, I have also annexed, but my document is not legible, my lord, not clear, my lord.
Let me find out.
Yes, my lord. Page 20 of the, my lord. Page 20, my lord, Kabang report. In my writ petition, page 36, it is there, my lord, but it is not, my lord. The top part is not there, my lord. The only question of law is that whether the report can be taken as a decision, my lord, whether it is appealable, my lord.
You see, you are a person from this state.
My lord.
You can't understand the report and you want me
No, my lord.
outside of the state to find out whether this report is.
Well, they have written it in English, my lord.
No. You see, whatever they have said,
No.
this report is a final decision.
My lord. But report, whether report can be taken as a decision, my lord.
You see, these people are not legally educated.
My lord.
They have written report,
My lord.
but this is a decision.
My lord.
You have any doubt?
My lord, yes, my lord, because, my lord, some facts is there, my lord. Because there's chairman, my lord.
Mr. Picha,
Yes, my lord.
you should take some time
My lord.
out of your busy schedule
My lord.
and move in this state
My lord.
and educate these Kebang authorities.
My lord, yes, my lord, I have, my lord. I have done some civil cases, my lord.
No. Have you given have you educated them that it should not be written as report? It should be written as a decision.
Well, Gaugura generally, what they do, my lord? When they say,
whatever they think they have done it.
when they say, my lord, this Kebang decision, they say Kebang decision. Yeah, either Kebang decision, yeah, mail order, my lord. This is not either a report. This is a report, my lord. This is not an order, not a decision, my lord. This is only a report submitted to the extra assistant commissioner, my lord. There has to be a decision by themselves, my lord.
This is a decision. They have clearly stated that that the claim made by so-and-so of so-and-so is baseless. Accordingly, the complaint and his members so-and-so will not claim if any further. So this is a decision.
My lord, this is a report submitted to the EAC, my lord.
We don't know if this is a decision. We are not entertaining the repetition to find out what is this. You have to challenge it before the civil court.
Well, this report, my lord,
We'll hold this to be a report, the decision. Now, did this, you see, according to Assam Frontier regulation,
no.
Administration of Justice regulation, please tell us what is the duty of Kabang and what is the duty of the Extra Assistant Commissioner?
Extra Assistant Commissioner has no role, my lord.
Correct.
My lord.
So therefore, what is the role of the Kabang?
Kabang, my lord, they generally, my lord, basing on a complaint filed by a, my lord, villager.
So they arbitrate.
They adjudicate, my lord.
They arbitrate.
Yes, ma'am. Yes.
Correct. So
Not arbitration, my lord, they adjudicate.
The
Because
act says
arbitration
arbitrate.
has been done away with the Civil Court Act, my lord.
So, no, but the act has not been amended. Now it still says arbitration.
Act has been amended, my lord. That AP Court, my lord, this Assam Frontier Regulation, my lord, has been amended in the Civil Court, my lord.
Nobody told us.
My lord, in that case, my lord, I may be allowed to file additional affidavit in that respect, my lord.
No, just
I'll
show us
not
that
record.
amended. Give us this
Civil Court Act.
volume 1.
Civil Court Act.
Civil Court Act is volume 16. And Assam
Volume 16.
16.
So pass it on. Give this book. Take it from me. No, this, what do you call this? No, give us this volume. No, give us this volume 1. Page
Volume
53, that, this.
As per, my lord, as per the Civil Court Act 2021, this arbitration, my lord, has been done away. In, I think, in section 50 or something, my lord. I forgot, my lord. It is there, my lord. In that case, my lord, this matter may be passed over for tomorrow, then I can satisfy your lordship, my lord.
Just a moment. You see, this is the amendment. Who is given? You have been this.
Yes.
You see this amendment. He has a copy. You read this.
And this is amendment. My lord, this is amendment, my lord. Civil Court Act, my lord. Civil Court Act.
This was amended Civil Court. That means Gabra has the power to adjudicate. Before it was like
Gabura has the power now. Gabura has, the arbitration has been done away.
No. In that principal act
Yes,
of regulation of 1947,
yes, my lord.
the word in section 37 is still arbitration.
Yes.
My lord.
That has not been done away with.
Done away, my lord. Civil Court Act 2021. Yes, my lord. I will satisfy, my lord. Civil Code 2021, my lord.
No, you have that.
This is the amended part, my lord. I will show the original, my lord.
This is the original act.
My lord. May I-
Volume 16.
Yes, I don't have now.
Oh, achha. You take this book. Give this. Yes. The 38-1.
Yes, my lord.
The word used is arbitration, it's still there. I did not find anywhere that this word amended, the word has been amended.
It has been deleted, my lord. It has been deleted. My lord, in the civil court, my lord,
With amendment.
6, Roman 6, my lord, Roman 6. And your lordship may see. Regulation.
The 38 is deleted.
Right.
So then if there's there's what do you call, there can't be a report. If the EAC is not not any authority.
Yes.
So the document which you're trying to show can only be an adjudication. You have to file an appeal.
But in that case also, my lord,
We close this matter, we declare it that this is a decision and you file an appeal.
my lord, in that case, my lord, can it be fixed after a week, my lord, so that I will try to satisfy you also, my lord.
No, because you see, when we are interpreting a document, there's nothing to be, because in the legal provision doesn't say that.
My lord.
You're yourself
My lord,
saying,
I would like to produce, my lord, additional documents in regard to various other judgments, decision of the village authorities of various districts, my lord. When they adjudicate a matter, my lord, they use the word, my lord, decision or order.
you see, is there a qualification given for a Gaungura, educational qualification given? Is he trained in law?
They are trained by, my lord,
They are not trained in law. Giving few lectures don't make them
Le-
trained.
legal service authority, my lord, they used to give some training, my lord.
Legal service authority, you see, they are not the training authority under the act for these people. But when we appoint judicial officers, we give them a mandatory 1-year training. We inculcate them in the art of writing. But Gaunguras are not inculcated in the right of judgment writing.
This is English writing, my lord.
That's okay, but they're not educated. We don't expect a Gaungura to be well versed in in law.
No,
This is a
firstly, my lord,
tradition.
the EAC does not have any authority to direct the village authority to conduct, my lord, this kabang, my lord. Firstly, he does not have any authority. Secondly, this is again a report submitted to EAC, my lord. This is not a decision, my lord. And that, my lord, we have allegation that this chairman, my lord, who was appointed by the EAC, my lord, is biased to us, my lord, because he is relative to the private respondent, my lord. So we have prayed for change of chairman, my lord, of Kaba, my lord. So, my
You
lord,
can't choose in a village, everybody knows everybody.
my lord,
In a village,
my lord,
if you have a house
my lord,
and a branch of the tree has fallen,
my lord,
everybody in the village will know.
my lord. That is why, my lord, because of the enforcement we have filed.
This is unnecessary pending litigations.
Well,
This is
I
just
may
wasting your
be
time.
allowed to file additional affidavit, my lord. I will file them.
You should have done it before we start hearing it.
Well, I was on the presumption that this report will
No,
be
no,
taken
don't
otherwise.
get a presumption. When you start arguing, then we have heard it.
My lord.
Nothing more. We can't adjourn on a drop of a hat. You check the mood of the court, then you find that the court is not in your favor, and then
No,
you
no,
say
no,
that
my
you
lord.
want to adjourn it.
Our condition is that, my lord, this report is never a.
We are
decision,
adjudicating it.
my lord.
We are adjudicating it.
There is no, my lord, statement of witnesses, my lord. No
There is no-
witnesses, no
there is
statement of
no
witnesses has
form.
been recorded, my lord.
Mr. Picha,
No, lord.
we'll give you not 1 day, we'll give you 1 year's time. Please show us a law where there is a format given how to write a judgment by a Keba.
That is why, my lord, give me 1 week time, my lord. I will
I'll
try
give
to.
you 1 year. We'll take it up after 1
No,
year.
my lord, only 1 week.
No, after a year.
Oh.
But then you'll have to show us any law where there's a mandate like Order 20 in the CPC,
Oh.
where the Keban
Oh.
is required to adhere to the judgment writing format.
Writing
There is
format, my
none.
lord.
But it has to be a decision, my lord.
You see, you are dealing with this for hundreds of cases. I have limited exposure in dealing with AFR matters when I come to Itanagar bench. I have dealt with only 5 or 10, not more than that. But that has got me sufficient experience. You show us any law where the village authority under AFR 1945 is required to adhere to law. They don't have to give a decision. They don't have to give reasons. They may just say, I like A, land belongs to A. That is good enough.
My lord, in that case, my lord, section, my lord, regulation.
At 2 o'clock, be prepared. At 2 o'clock, we'll take it up. You're not adjourning. After starting giving some time, then we can't adjourn the matter like that. If you have to do after a year. Mhm. Yes, yes. At 2 o'clock. Yes, none appears on call for the petitioner.
Your Honor, here I am appearing on behalf of respondent, Mr. R. Saikia. As he could not turn up, as his health is not well, Lordship.
Just a moment.
My lord.
Your affidavit has to be rejected. You can't serve it on a lawyer. If you have to serve it to respondent number 3, you do it to him, not to Arup Bhattacharjee.
Arup Bhattacharjee, they are associate, my lord.
I don't know.
Because in person, I also don't know that person, my lord.
No,
Because
I
this court has
don't know.
directed me
This
to
is not
take-
the way to serve. You see, there is a manner prescribed for service of summons.
My lord.
It does not say you serve on a representative.
My lord.
He must either be a male adult member of the family. I don't know if lawyer is a member of the family. You may call him brother.
My lord.
Doesn't make him your member of your
My lord,
family.
yes, my lord. That is true, my lord. What happened, my lord? In my presence, my lord, this Arup Bhattacharjee has called this private respondent, my lord. And he accepted the notice, my lord.
But it's not a service. You can't serve on a representative.
It was accepted, my lord. White order dated 8/4/2024, my lord.
You
White
don't
order
recall
dated.
that. It can't be. It's not a good service. 8/4 has to be recalled. He's not an adult member of the family. He can't be expected. He has to be a recognized agent. Your affidavit does not say that he is a recognized agent. He is not an adult member of the family. So service of notice on others, I can't
The
imagine.
problem here is, my lord, this person, my lord, has give, my lord, may please come to, my lord, my course title, my lord. This is the address, my lord, page 8, my lord. Page 8, my lord. This is the address of the, my lord, this private respondent. So and so, Advocate Guwahati High Court, Eternal Province, so and so. In the RTA application also, my lord, same address, my lord. Page 31, my lord, of the RTA application, my lord. He has given the address of this High Court, my lord.
He's a member of your bar? No.
He's a member of bar, my lord.
Then you'll find the address there.
My lord,
he is not a regular practice advocate, my
No,
lord.
no, he may not be, but if he's a member of your bar,
Yes, my lord.
your bar register will contain their address.
Uh,
You can't, you see, you are the petitioner.
my lord.
The address to be served will be a correct address.
Address, my lord, we have the address.
No,
is-
you could serve it to your, if he's given that address,
My lord,
you could serve it on your office secretary of the bar association.
my lord.
Because then the bar secretary can accept it if his address is bar library.
Oh. We have, initially we have served notice upon the responsible register post, my lord. The notice came to the bar, my lord, nobody accepted it. So we were directed to take Dusty, my lord. So Dusty also, my lord, he is not a regular practicing advocate, my lord. So we contacted his friend, my lord.
Then the only way is that you'll have to serve it by newspaper publication. Because you seriously think about it,
My lord.
I know you because you appear in my court.
Right.
Now somebody will come and say that, okay, Lordship, your Lordship will accept the notice. And when you go to Itanagar,
Right.
you give it to Mr. Picha.
Right.
I can't be a postman.
In my presence, that call has been made.
No, no, I can't be a postman. So therefore, why your brother, Mr. Arup Bhattacharya will act as a postman?
He is the best known person to him, my lord, the private respondent. I have been also informed by Mr. Arup Bhattacharya that he has not come to collect this notice, my lord, this petition, my lord, despite the call, my lord. Despite the approval made by him, my lord. It seems he is not interested, my lord.
Okay, what is the nature of information you wanted to be revealed? Where is
My lord,
that?
I am the PIO, my lord, yes.
Hmm?
I am the PIO, my lord. Yes.
Correct. What is the direction to you? What is the information you are asked to reveal?
Yes, my lord, information with regard to, my lord, scheme under Jal Jeevan Mission, my lord.
Where is the document?
Page 31, my lord.
Page 31.
Is the application, my lord. I have furnished the information, my lord. It is very voluminous, my lord. So I have craved, my lord. Period for which information sought, my lord, is from 2020 to till date, my lord.
So there is a mobile number given
Yes, my lord.
at page 31.
Yes, my
You
lord.
can serve it by WhatsApp. We'll permit you.
Yes, my lord. That may be permitted to me, my lord. My lord, and my lord, I have one prayer also, my lord.
And there is also an email. Why you want to service to somebody else?
All right, my lord. I may be allowed to take both the mode, my lord. WhatsApp and
okay.
email.
Mr. V. Pichal, I'm counsel for the petitioner. And Mr. Sorry, I forget your name always.
B type Odia also. On behalf of RSIK. B type Odia.
Typodia. I'm sorry, Mr. B. Typodia, and counsel for respondent number
1 and 2.
1.
1 and 2, my lord.
1 and 2.
Yes, sir.
Okay, 1 and 2. Next payment. Notwithstanding the order dated 8/4/2024, accepting notice on respondent number 3 to be duly served. on notice being served to Mr. A. Bhattacharjee, stated to be a learned counsel of this court, the court finds that at page 31 of the writ petition, the respondent number 3 has provided his 2 mobile numbers as well as his email address. Therefore, in addition to notice already served, the court is inclined to direct the petitioner to take fresh steps for service of notice on respondent number 3 by sending WhatsApp message in any of the 2 telephone numbers, mobile numbers, as well as in the email address available at page 31 of the writ petition. The process, the steps shall be taken within 2 days. The process shall be routed to the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next list on. Before that, interim order past date stands extended till the next date of listing. Next para list on. Within 2 weeks, you can do it. Well, list after 2 weeks on a date to be fixed by the office.
In the meanwhile, my lord, this direction will be given to this respondent 1 and 2. My lord, I have made one statement, my lord, though I do not have the record, my lord. I have stated that after filing of RTA, my lord, within 8 days they have preferred first appeal. So, scan copy of the application before a second appeal may be called for. Scan copy of second appeal, my lord. Scan copy of second appeal filed by the private respondent.
Do you file an application? This is not a part of your prayer.
This is not a part of the prayer. Order.
So make an application, we'll do it because we can't pass orders on abstract. Second appeal before whom?
The Information Commission.
The Information Commission, that is respondent number 1.
1 and 2. One.
The appeal is filed there.
Well, yes, well, they have filed second appeal. Order. Now, in the second appeal, they have stated first appeal was filed on 26/6.
No, I'm not on that.
Right.
When you filed this writ petition, that appeal was not there.
It was there, my lord. We were not given the copy, my lord. So the scan copy would be required, my lord. There is only 2 pages, my lord. I have stated in my para 4, my lord, on 28/6/2022, my lord, they have preferred first appeal, my lord. I have received the RTA application on 26/2022, my lord. And on 28/6, after just 8 days, my lord, they have preferred first appeal, my lord. So I am telling the entire proceeding pending before the Information Commission.
I'm not being able to follow you. You see, in this writ petition, the impugned order is 16/3/2023.
I'm also challenging the entire proceeding, my lord.
No, that's okay.
Yes, ma'am.
But the order impugned is 16/3/2023.
Yes, ma'am.
In this second appeal, what order was passed?
I was imposed, cost was imposed upon me, my lord.
In the second appeal?
Yes, my lord.
No.
Yes, my lord.
How much cost?
25,000, my lord.
No, that is already impugned here, 16/3.
Yes, I have impugned it, my lord.
Then?
And my lord, also I am challenging the entire proceeding, my lord.
That's okay.
My lord.
So this 16/3 is an order passed in second appeal.
My lord, 16 in pursuant to the second appeal filed by them, my lord, I was passed with this impugned order, my lord.
Okay, they will produce it when they file the affidavit. Because that is under challenge. We won't direct them to produce the documents right now. They have to file an affidavit.
Malad, other day, Malad, I was submitting, Malad, the network was not working, Malad, I would like to submit this. Yesterday I had submitted something, Malad, I could not produce, Malad, because of poor network. Malad. The adverse position, Malad. State, Malad, state cannot perfect its title by way of adverse position.
No, that is 142 they have invoked. They have invoked 142. Okay. This also. This after 2 weeks, no? Okay.
No, obliged.
Ma'am, my lordship, we need some more time to file affidavit.
Pardon me?
We need some more time to file affidavit.
This is from which district? Anjao.
Yes, ma'am.
How much time you want?
3 weeks. Ma'am.
We'll direct that if in 3 weeks this affidavit is not filed, the deputy commissioner Anjao will be personally present with all the records of issues of LPC. To respond number 4. Then we'll give it to you. All sides are represented. Yes, okay, one more and then government advocate pays for further 3 weeks time to file affidavit in opposition in the matter. Next paragraph. On a wanted query of the court. Government advocate has submitted that she is yet to receive Paravoi's comments. What's that? The next paragraph. In this case, the petitioner claims inheritance of a particular land in respect of which land possession certificate was issued in favor of respondent number 4. Next paragraph. It's such facts, the non-filing of affidavit in opposition by the director Land Management Department. Respondent 2 is also not filed.
Not yet.
Respondent 2 and the Deputy Commissioner, Anjao District, is not at all appreciated. Next paragraph. Of the state respondents are granted time till 19/6/2024 to file their affidavit in opposition. Full stop. On failure of the Deputy Commissioner, Anjao District, within bracket respondent number 3, to file affidavit in opposition within the time allowed, comma, he or she shall be personally present in court along with all relevant records relating to issuance of LPC to respondent number 4 and be prepared to assist the learned government advocate to respond to the court queries. Next paragraph. List on 21/6/2024 for personal appearance of the Deputy Commissioner, Anjao District, on his failure to file affidavit in opposition by 19/6/2024. Next paragraph. The personal appearance of respondent number 3 would not be required if affidavit in opposition is filed within 19/6/2024. Next paragraph. The learned government advocate shall transmit a copy of this, downloaded copy of this order to the respondent number 3 to put him to notice of his, to put him to notice of this order. Right.
May I, Lordship? Lordship, here in this case, Lordship, government is supposed to file their affidavit, Lordship.
My lordship, our affidavit is ready, my lordship. We'll be filing today, ma'am.
Thank you, dear. Okay. What says the representative? The learned government advocate submits that she will be filing an affidavit in opposition in course of the day. Right, and then just one more. Stop. According to matters since adjourned today, list after
Interim may be continued, Lordship.
interim order passed arrest has extended to the next date of this time.
Much up.
Number 20 and 21.
Madam, I am appearing for respondent number 2, madam. I have received the copy, my lord.
Just a moment.
Affidavit is almost ready, my lord. Maybe this, after 1 week, my lord, I will file the control reply, ma'am. In both the cases, ma'am.
Yes, in your case also, same thing. Why you did not file an appeal? Why the writ petition has been filed against the KEBA decision?
Lordship.
From the orders passed in the KEBA,
Yes.
appeal is permitted under the before the civil court So why should we entertain a writ petition?
Lordship, as we have filed, earlier, Lordship, we have filed one writ petition regarding the same matter, wherein the matter was disposed of, and with a direction and with a liberty to approach to a appropriate forum to the respondent. Accordingly, they have approached the village authority.
So against the order of the village authority,
Yes, Lordship.
an appeal can be filed before the civil court.
Yes, ma'am.
There, Lordship,
They
they
should
have,
be
they have
go
not
for appeal.
appeared. They
The
have not.
decision passed in the favor of us, my lord. Respondent number 2, my lord. They should be go for appeal, my
Putting a question to him, please let him respond.
They have not filed appeal, Your Honor. They have filed for appointment of arbitration, Lordship, which is not there.
No, you
So
are,
accordingly,
you are challenging the order.
yes,
You are
Lordship.
saying that the order of the order passed.
By the DC, Lordship.
By the ADC.
Yes, Lordship.
Where is that order? Page 66.
Yes.
Therefore, they have referred it to Keba. What is wrong in this order? We find an affidavit, we'll see them. Both sides are represented. The learned counsel for the private respondent. Praise for is granted. How much time?
1 week, ma'am.
1 week's time to file affidavit in opposition in the matter. Just stop. This IA.
My lord, my submission may be recorded, madam. My submission may be recorded, madam. They should go for appeal, madam. As for seven decision passed in favor of us, madam.
You please argue on merit then. If you see, without filing an affidavit, if you can give advice, please argue. To whom you are advising? You are advising to Mr. Tapuria. Do you think he does not know the law?
Yes, madam.
You are more learned than him?
Yes, madam. I am written in the.
No, that's okay. I am asking you a question. You are more learned than him?
Sorry, madam.
Why you are advising the counsel? He knows what the law is. We have to educate here. So either you file an affidavit or start arguing. What do you want to do?
After affidavit, madam.
Okay. Okay. All sides are represented. This interlocutory application shall be considered on the next date. This contempt petition. Yes, what is your prayer in the contempt petition?
My lord, affidavit is almost ready, my lord. I filed
Okay, same order,
the next week.
contempt petition. The applicant and so the petitioner and the respondent is represented, are represented on the prayer made by learned counsel for the private, for the respondents. List after week, so as to enable to file affidavit in opposition in the matter. You are appealing for respondent number 1.
Yes, sir, that's it for 1.
You have anything to say?
You was it.
Additional advocate general is here? No. Please call your additional advocate general, Mr. Raman. Please call him. Please wait for some time. Let Mr. Raman come. Keep it here.
That impleadment application. I would also make a small submission in this case. Instead of impleading the applicants, if it can be converted as an intervener only to the extent of hearing with regards to the tender process. Whereas I cannot dispute the title as well.
You are the applicant, right?
I am the applicant, Milord.
Okay, the day after, the day before yesterday's matter.
Yes.
Or that Friday or Thursday's matter, no?
Yes, yes.
Oh, okay.
Otherwise, Milord, that other one, rule 3 and 8 is in my favor, Milord. Now, we will not go into that, Milord, except.
Yes.
No objection.
To his impleading as a respondent or intervener?
Opposite party.
Opposite party in the IA.
I am read petitioner, opposite party.
This okay.
Yes.
You are the read petitioner.
Yes.
My question to you is that you have any objection to implead him in what capacity, as a respondent or as an intervener?
Intervener, Lordship.
Okay. Maybe even the respondent will also do, because I will be not disputing her title right over the lands and claiming.
She has some reservations.
Okay,
with regard
well,
to the question of
okay.
title.
Because
So
issue
yours
is
only with regard to different
Tender
aspects.
tender
on
part.
tender part.
Tender part. As an intervener.
Okay. Heard. Mr. T.T. Taranan, counsel for the applicants, also heard Mr. Tarak Leonard, standing counsel for the Mr. G. Tarak Leonard, standing counsel for the RWD. For the government will be there, respondent number 1. For the state, I will speak Pango Government Advocate for the state. And Ms. Penn Engine, counsel for the writ petitioner, who is the
Opposite parties numbers.
opposite party numbers
6 to 59,
6 to 59. and this-
61 to 67, 69 to 97.
Please give it again slowly so that
Yes,
you write.
yes,
Please say slowly, you can write
yes.
as follow numbers, opposite party numbers. Next one. This interrogatory application has been filed for impleading the applicants in the connected writ petition filed by the opposite party numbers 6 to, what is the number? 6 to? No.
6 to 59.
No, 6 to 15, you are appearing. So it will be
Yes.
6 to last.
Uh,
13, 6 to 5 to 15, 5 to 15 as intervener.
5 to 50, 5
Yeah,
0, 5 to
yes.
50,
No, 1-5.
1 5.
5 to 1-5 as an
1-5.
intervener.
So only that much respondents,
right.
petitioners are that much. 1 to 15. Next para. The learned counsel for the writ petitioners have submitted that they have challenged the tender in question as the work pertaining to the said tender would be carried out on the land which they claim to be theirs.
yes.
Stop. Accordingly, it is submitted that as the interest of the applicants is limited to the tendering process, the said applicants cannot be permitted to challenge the title over their land. Full stop. Next paragraph. The learned counsel for the applicants have submitted that their interest only lies with the issue of the tender process being stayed by this court.
Yes.
For various factors which are required for the various factors which requires an early adjudication of the issue, so that the tender process is brought to its is brought to a close. Stop. He submits that the applicants do not want to assail or question the title of the writ petitioners over the land which they claim to be theirs. Next paragraph. Accordingly, on a query of the court, the learned counsel for the applicants has submitted that the applicants would have no objection if they are allowed to participate in the writ petition even as an intervener. Insofar as their limited stand in the writ petition would be only respect of the tender process. Full stop. Accordingly, this the court is inclined to allow the impleading of the present applicants as the interveners in the connected WPC
171.
171 AP of 2024. For the purpose of taking their stand in respect of the tender process, which is questioned by the petitioners, petitioners. Next one. The application stands allowed to the extent as indicated above.
Grateful.
Next paragraph. The so in the petition say and agent counsel for the petitioners, Mr. G. Tarak, learned standing counsel for the RWD. We have also heard Mr. T. T. Tarak, learned counsel, whose application for whose application being IS Civil 74 AP of 2024 was allowed to the extent of permitting the applicants therein to appear as intervener in this rate petition. Next paragraph. Since the cost title is already available with the interveners, they will provide amended cost title of this rate petition, disclosing their status as intervener, which shall be filed before the registry within 3 working days.
Correct.
Full stop. The registry on receipt of the same shall incorporate the amended cost title in the rate petition by substituting the freshly typed out cost title at pages 3A. 3A and onwards, and the existing cost title from page 3 to 26 of the edit petition shall be struck off, but retained in record. This will remain, it will be struck off. And the amended cost title will be in the front.
Correct.
Correct?
Lordship, struck off, I'm not getting, struck off what, Lordship?
Page 4 to 26 will be struck off.
Yes.
But it will remain in the record.
Yes.
Substituted cost title will come
Okay.
as
Interview.
Yes.
3A onwards, whatever page it is.
All right.
3A or 3.1, it should be what page is? 3 within bracket 1 onwards. Okay, next paragraph. The interveners are permitted to file their affidavit with a limited stand insofar as the challenge to the tender process is
Tender
concerned.
process. Correct.
All right.
Grateful.
List after how much time?
5th.
Lordship, the main case is already
Main
fixed on
case
5th.
already order is passed.
On 5th.
On 5th.
Okay, list on 5.
Main item has to be listed on 5th.
In the main case, list, the date is already there.
Already,
Yes,
the order
yes,
is
it's
already
already
there.
there.
Okay. We list from 5/6/2024 as already ordered. As already directed by order dated 22/5/2024.
All right.
Okay, Mr. Ravan. Just a moment, there is something. If you have your own mind, what I'm trying to show you.
The item note 20 and 21, ballot.
Yes, contempt on those matters. This is contempt matter to Mr. Naval. Contempt. Contempt matter.
Contempt, my lord, my brother is having my lord contempt.
We take this file as something. Now, it's live telecast going on. What? Everything is live. It's available in YouTube. It is available in YouTube. This is video transfer.
Yes, my lord.
This prayer for bail is rejected. The yes. Then we have to take.
So to maintain uniformity of the rate and to find out the most advantageous because without the technology low rate, can it be?
Just a moment. Just a moment. Just a moment. Just a moment. The where is the date of opening of the bid? Because at page 64, this is already past. Tell us 207. Two 207. No, 207 is something else. The last date of submission of so and so is on 21/9. Yes, Mr. Radan, what you are trying to show, page number? Two one six.
216. My lord has got it, my lord.
Yes, 216.
My lord, may I read, my lord? Upon submission of reports and recommendation by the high level technical committee constituted by so-and-so, dated so-and-so, and within the terms of reference and mandated by so-and-so, following guidelines with terms and conditions are hereby laid out for adoption in the Department of Power with immediate effect for exercising in the course of tender, bid process, bid evaluation and award of contract, works of projects and schemes, my lord. My lord will kindly see serial number 4. Justified price, bid price ranges category wise to weed out unrealistic, very low and excessively high and obstructive bidding. The justified ranges of bid prices of materials and works as determined for respective category-wise areas shall have to be adopted and adhered to in the bid evaluation process of tenders and the contract award thereof for execution of the Department of Power as contained in the following respective annexures, my lord. Category 1, my lord will say category 1 includes the capital electrical division, so and so, Likabali electrical division also. And these were the department has categorized three types of categories, my lord. The places which are near to the towns or which are in the towns, their rates, justified rates are lower. Those who are in a bit higher, this more difficult terrain, their bids are justified rates are a bit higher. And the most difficult terrains, the bids justified rates are the highest, my lord. My lord will kindly see, therefore, category 2, Rupa Electrical Division, Bomdila Electrical Division, these comes, my lord. Then category 3, my lord, Tawang Electrical Division.
No, you see what is happening. Your intentions may be very good, but you issue a memorandum on 18/9.
Yes, my lord.
Correct. Last date is 21/9.
Yes.
Therefore, unless you show that you have served him, because if 29, that means one gets only 2 days.
My lord,
to submit.
My lord, this memorandum was not to be circulated, not to be given to any of the bidders, my lord. This was a mechanism adopted to be adopted by the department itself to find out the workable justified rates, my lord, quoted by each bidder, my lord.
If this was not to be circulated, why clause number 1 and clause number 2?
No, this was not, these were the mechanism to be followed, my lord.
I understand.
Yes.
But look at clause number 1 and 2. One is pre-bid site inspection. If you don't tell them, how will they go and visit site? So this is intended for the tenderers. You can't say this is not, memorandum was not intended for the tenderers.
My lord, here the main question is the bid justified rates, my lord. In the this SBD, what the SBD talks about the most advantageous bid, my lord. If my lord kindly comes to page 87, sorry, my lord, 110. One year. Clause 36, abnormally low bids, my lord. An abnormally low bid is one where the bid price in combination with other elements of the bid appears so low that it raises material concerns with the employer as to the capacity of the bidder to perform the contract for the offer bid price, my lord. My lord, and then my lord will also come to clause 38, most advantageous bid. Having compared the evaluated cost price of bids as per ITB 34 and applying the provisions of ITB 35, the employer shall determine the most advantageous bid. Clause 38, my lord. The most advantageous bid is the bidder Yes, yes.
Just a minute. Yes.
Closed
Yes. Yes,
38.
I have read it.
Yes.
Hmm.
Having compared the evaluated cost price of each as per ITB 34 and applying the provisions of ITB 35, the employer shall determine the most advantageous bid. Alternatively,
What is this BDS
my lord,
specified in BDS?
bid,
What is BDS?
bid, uh, bid data sheet,
Bid data sheet. Okay.
bid data sheet. So alternatively referred to as the L1, my lord.
Mr. Khan, I've not been able to follow
And
you.
written clarification is provided under clause 36(2). In the event of identification of a potentially abnormal low bid, the employer, unless otherwise specified in the BDS, may seek written clarification from the bidder, including a detailed price analysis of its bid price in relation to the subject matter of the contract scope, delivery schedule, allocation of risks and responsibility, and any other requirements of the bidding document. My lord, this was also followed. They have been asked to justify, my lord. Their justification was not accepted, my lord. Then, therefore, he has quoted, my lord will kindly see the amount quoted, my lord. What percentage, my lord, at page 162. $262, my lord. Sorry, my lord. 262. That is in the landscape folding, my lord. Page 262. My lord, will kindly see, my lord. May I read, my lord? The 262, the recommendation and the findings of the tender board, my lord, opening board.
Just a moment. Okay,
My lord, I was,
you. Yes, you come to page 260.
yeah, my
Come to
lord,
page 260. Come to page 260. 260.
260. Yes, madam.
260. Yes. Item number 12.
Item number 12.
Last, the second last.
Yes, my lord.
Correct. Now, what is the rate quoted of three people?
Item 12.
Yes. One is the first man is basic rate and without taxes, it is 8 lakh, sorry, 80,082, correct? First bidder. Second bidder is
Yes.
1 lakh 17,600. Third bidder is 1 lakh 12,500, right?
Yes.
Now look at the internet rate. Correct. Now, what according to you will be a justifiable rate? Please tell us.
5 kVA.
Now you know what is the viable range.
Yes, my lord. This,
So,
no, in any case, my lord. This might
So
be,
you see-
this is, my lord, of
No,
course.
I don't know, you see, this is how I spend my time. Correct.
Yes.
You have asked for one item, in this, I have chosen only one as
Yes,
a, as a rate. Now, if you want to argue about the viable range,
Yes, my lord.
then you see in the market, the things are available half the cost of what has been bid.
Yes, my lord.
So therefore, how do you distinguish? What is the correct rate? What is the wrong
Yes,
rate?
my
What is
lord,
the right rate?
that is, my lord, I don't know how my lord has found out in the net, my lord, but in actual price, my lord, this includes so many of tax and all, and by the time it reaches,
You see, transformer, what is the rate of GST?
that I have no idea, my lord.
Huh?
18% GST. By the time, my lord, it reaches here, my lord, that
No,
might
that's
be a rate. So,
No, that's okay. You can add up how much you can add up. It not be 100%. Correct. 18% interest, 18% GST, transportation 20%.
yes.
So still you see viable range when you're addressing at least this bench.
Yes, my lord, that's exactly, my lord. I understand, my lord. But what, my lord, here we have to determine
Yes.
that price. This is the comparative statement, my lord, at page
262, yes.
254. My lord,
262.
254 comparative statement, 262 is the comparative statement.
Yes.
Now,
What is his name? Petitioner's name?
Kashmiri Lal Construction, my lord. Kashmiri Lal Construction.
Kashmiri Lal Construction.
Yes. May I read, my lord? Out of
Kashmiri Lal Construction, 139.
yes.
So 139 is a little less than 140.
My lord will say why, because there is a justified rate. My lord will say MS Kashmiri Lal Construction has quoted minus 30.63 below the tender amount and is minus 24.8% below the minimum justified amount. A justified amount has been fixed, my lord. These are the experts who have fixed. They have taken into account the market rate, everything. And then they have identified justified rates for three different categories of divisions, my lord. Now, he has, as per the justified rate of the government, he has quoted minus 30.63% below the tender amount and minus 24.8% below the minimum justified.
Just a moment.
Okay.
Just a moment. Let the additional general complete. Come to you.
262.
Where was that document? The impugn document, where is that?
Impugn 216, my lord.
216.
Annexure 10. Two 18 is for the rates. Rates for category 1 to from 221 it is for category 2. Justified rate, my lord, for this item, my lord, which my lord has found out, my lord. This is at page 219, serial number 35, 11.11/0.433 kV distribution transformer, 25 kVA 3-phase aluminum wound DTR. I think that is the one, my lord.
Yes.
Justified rate minimum is 133.58, 583, my lord. And maximum is 147,493 point.
So therefore,
my lord, this is a justified rate fixed and determined by the experts. My lord. I don't know whether this is correct or not, my lord. But this has been determined by the experts. Whether this is correct, they have to put into challenge this. That these justified rates, these are not, these cannot be the justified rates. These are the justified rate worked out by the technical experts, madam. And this, the same article, madam, same article 4, this is for category 1 divisions, madam. It will differ for category 2 divisions, madam. Of course, by comparing with the rates.
you please read page 216.
Yes. 216.
Clause, 4 of that memorandum.
Yes. Clause 4, yes. To weed out unrealistically very low and excessively high and obstructive bidding. The justified ranges of bid prices of materials and works as determined for respective category wise shall have to be adopted and adhered to in the bid evaluation process of the tender and the contract award thereof for execution in the department as contained in the
Correct.
following.
Now, these rates were worked out when? You don't know about this.
My lord will kindly see the top, my lord.
Yes.
Upon submission of reports and recommendation by the high-level technical committee constituted by so and so, dated 28 August 2023, and within the terms of reference and as mandated by event numbers dated so and so, 1st September 2023. Following guidelines with terms and conditions are hereby laid down for adoption in the Department of Power with immediate effect for exercising. There was a high-level technical committee constituted. (216), my lord.
Okay, just wait, I have not heard Mr. Teja. Let me hear him first, then I'll come back to you.
My lord, can I complete, my lord? The
No,
second, there were
just
three.
wait, because I have not heard him. I just
Yes,
remembered he was asking to say something, but I did not hear him. I
Yes.
started hearing you first.
Yes, yes, yes.
282. Yes.
Now, in this minus of the big meeting, I don't know if this have close to number 5. There's a customer difference of this yes, we will be getting it. All of the findings of another thing, it has been made applicable. It has been informed. We were not informed. We have been taking a surprise. This is a lesser level tender. So we would like to work the minimum interest.
No. That argument is, will tell you, is not, cannot be entertained.
Page 93.
Page
93.
93.
Amendment of legal. At any time prior to the deadline for submission of it, as well as the amendment document by issuing addendum original amendment. The addendum original amendment will be in writing and appear on the e-procurement system, and those even notices automatically sent to those leaders who have started working on the procurement or as other words specified EDA. Any addendum original amendment issued shall be part of the daily document and shall be to have been communicated to all the readers. To give prospective readers reasonable time in which to take addendum original amendment into account to preparing their report. The approval may extend the deadline of the submission of this process to 90 days. It has to be communicated to us, the readers. And based on that original number, we will prepare our bid document. So this notification was not this memorandum, this is the memorandum, was never communicated to us, either from email or by email. Memorandum. This is only for addendum, original and amendment. It does not say about memorandum. Even if it is applicable, they have to communicate us. Without communicating us, they cannot take us by surprise. We prepare our bid document, basing on the process of the LIT, LPD. Now there is no variation problem. Now the bidder will surely not make a price bid at the lowest interest, lowest profit to give. Now basing on that, we have submitted our bid and the price bid. Moreover,
But in the price bid also, my lord. While submitting our price bid, my lord, We have submitted our price bid, they have sought our justification. We have given them the justification by taking into account the dealers for the shop which they have given us the rates. Page 230, they have sought the justification of our rate, so we have furnished them the reply. 229 is the justification they sought, 230 is our reply. 229 is their letter seeking justification of rate. 230 is our reply. Here, we have submitted them our reply, basing on the market value of the rate. Page 34 may please come, page 234, down below, we are ready to perform, by execution of this work also we get 14% profit, net profit in interest 14%. So starts and 235, 236 is the rate given by the dealers. 236 we have also made our survey. On the basis of rates given by us by the dealers, we have submitted our bid price bid. 236, 237, again, page 239, page 239, this is all this is the market rate, which have been given to us by the dealers. 239, 241, of each item. This is the quotation given by the dealers. Again, 243, we have also prepared our survey. On basis of our survey and the rate given by the dealers, we have prepared this our price bid. 245, 244, 245, 246, 247, 249, and 250, 250 to 2. There are other documents also, which are, because they are not legible, because of which we have not annexed it. Till 255, 253, we have submitted our justified rate, basing on the market rate given to us by the respective dealers. Since there was no variation clause, on the basis of that, on the basis of NIT and SBD, we have submitted our bid. Even, may kindly come to page 110, of the writ petition. Page 110, 110.
Yes.
110, clause 37, May I read, 37.1, unbalanced or front-loaded bids. The bid that is evaluated as the lowest evaluated cost price, shall be considered by the employer as unbalanced or front-loaded. If the quoted price of supply process exceeds the percentage specified in BGS of the total quoted bid price after evaluation and excluding GST. In such a case, the bidder shall be required to furnish an additional performance security pursuant to ITB 4.44.1. Since there is no variation clause, madam, if they feel this fit, madam, that yes, we are the lowest bidder, madam, they should have taken our that bid, madam, which is lower than the justified rate. They, in that case, that amount of range, madam, between the justified rate and our rate, madam, it should be taken as taken consideration as unbalanced and front-loaded bids, madam, and for which they should have taken additional performance security, madam. And finally, madam, page 263, madam.
263.
Yes, madam. This is the comparative statement of abstract part, madam. They are confused, madam. Even we are confused, madam. What has been said here? 263, madam. This is the abstract, madam, part of package, madam. Madam, deviation assessment, last column, madam. 263. It is a part of comparative statement. Deviation assessment, madam. Tender amount minus 25. This is the aquarium, madam. Assam Electrical minus 12, madam. Kashmiri, madam, minus 30, madam. Now, minimum justified rate amount, madam. In case of the one, madam, serial number 1, minus 19. In case of serial number 2, minus 5. In case of serial number 3, minus 24. This has been given minimum justified amount. Now, maximum justified amount, madam, they have given for serial number 1, minus 27. Serial number 2, minus 13. Serial number 3, minus 31. If that be applicable, madam, then we are under the zone of consideration, madam. Our rate is, madam, good enough, madam.
I did not get you. Please repeat again. %71. If we take this into consideration, madam, I am within the justified rate, madam. Madam, they, madam, if there would have been, madam,
any justified, a variation clause, my lord. This is a if there would have been, my lord, a variation clause, my lord, obviously, my lord, we would have submitted our price with basing on that, my lord. But, my lord, there is no such minimum or maximum justified clause, my lord. So basing on the market rate, my lord, which we have quoted our price, my lord. Now, without informing us, my lord, they have deviated from the tender conditions.
Please continue.
Yes, my lord. Para 26, my lord. Equally well settled principle of law relating to contract is that a party to the contract can insist for performance of only those terms and conditions which are part of the contract. Likewise, a party to the contract has no right to unilaterally alter the right to any additional terms and conditions in the contract unless both the parties agree to add stroke alter any such terms and conditions in the contract. Para 27, my lord. Similarly, it is also a settled law that if any party adds any additional terms and conditions in the contract without the consent of the other contracting party, then such addition is not binding on the other party. Similarly, a party which adds any such terms and conditions has no right to insist on the other party to comply with such additional terms and conditions, and nor such party has right to cancel the contract on the ground that the party has failed to comply with such additional terms and conditions, my lord. Para 30, my lord. So far as the four special conditions are concerned, these conditions were also not part of the public notice, nor they were ever communicated to the bidders before auction proceedings. There is no whisper of such conditions being ever considered as a part of the auction proceedings, enabling the bidders to make their compliance in case their bid is accepted. Para 31. In our considered opinion, it was mandatory on the part of the respondent authority to have published the four special conditions at the time of inviting the bids itself, because how much money rent the bidder would be required to pay to the state on allotment of plot to him was a material term, and therefore the bidders were entitled to know those material terms at the time of submitting the bid itself. It was, however, not done in this case. Para 33. The learned counsel for the respondent state, however, argued that it was not necessary for the state to specify the conditions relating to forfeiture and four additional terms and conditions in public notice because they were already part of RBC, which is applicable to the Najul lands in question. 34 more. We find no merit in this submission for more than one reason. First, the public notice inviting bids did not even contain a term that all the provisions of RBC will be applicable to the auction proceedings. And second, the relevant clauses of RBC, which, according to the state, were to govern the auction proceedings, ought to have been quoted in verbatim in the public notice itself. It was, however, not done. Para 35, last paragraph. In our opinion, the object behind publishing all material terms are threefold. First, such terms are made known to the contracting parties bidders. Second, parties bidders have become aware of their rights, obligations, liabilities for each other, and also of the consequences in the event of their non-compliance. And third, it empowers the state to enforce any such term against the bidder in the event of any breach committed by the bidder. And lastly, when there are express terms in the contract public notice, then parties are bound by the terms and their rights are accordingly determined in the light of the such terms in accordance with law. So no notice was given to us, my lord. They have taken us by surprise, my lord. Yes. So why, my lord, I'm only for enforcement of this NIT only, my lord, and the SBT.
My lord, I will try to justify our page 216, my lord, the memorandum. 216. My lord, this is a memorandum. How to evaluate the justified rates of the bidders, my lord. And this is to circulate to the entire bidding divisions circles, my lord, that these are the justified rate we have formulated. You cannot deviate from that. Now, this is not a part of the bidding document. SBD. This is an internal mechanism to be followed by while evaluating the financial bid of the bidders, madam. We don't say that this is a part of the SBD. The technical experts, they have come to the finding that these are the justified rate, workable rates in our state in this category of places. I don't know what is the market rate. It might be low, it might be high. I don't know. But for the state, since we have different terrains of the difficult topographies, and the justified rate varies from one category to another. Madam. We have categorized it into 3 categories: the easy category, the mid category, and the tough category. Madam. Accordingly, justified rates have been worked out. Madam. And these rates have been circulated to each tendering authority, that while evaluating the tender bids, you have to follow these justified rates. This is not a part of the tender document, madam. What is required at page 93, my lord, what my learned friend said, that any addendum, corrigendum, amendment at page 93, what he was referring to, that talks about the addendum, corrigendum, or amendment in the SBD, my lord. Tender bids, my lord. This is our justified rate. This is not a part of the tender bid, my lord. So this is his very contention, that this has to be intimated to us, informed to us, is totally incorrect, my lord. This is a totally secret internal mechanism to evaluate the financial bid, justified rates. Now, my lord will kindly come to page 110, my lord.
Yes.
I have already taken, my lord, earlier also. Clause 36. 36.1, my lord. An abnormally low bid is one where the bid price in combination with other elements of the bid appears so low that it raises material concerns with the employer as to the capability of the bidder to perform the contract for the offered bid price. Then 36.2, in the event of identification of a potentially abnormally...
You have already read.
Yes.
This you have already read.
And then, my lord, my learned friend was harping on 37.1. 37.1 will come only after 36.3, my lord. If his bid is not rejected, after the justification he has given, and his justification is accepted, that in this low price also bid we can perform, then the difference between that to secure that 37.1 will come into play, my lord. He has been given to clarify as per clause 36.2 and 36.3, he has been rejected, my lord. Now, he cannot now claim. If he's not rejected, then he can take the claim for 37.1, my lord. If my lord have got me, my point, my lord. After evaluation of bid price analysis, in the event that the employer determines that the bidder has failed to demonstrate its capability to perform the contract for the bid price offered, the employer shall reject the bid. Now, after that only, the bid price that is evaluated as the lowest evaluated cost price shall be considered by the employer as unbalanced or front-loaded if the quoted price of supply portion exceeds the percentage specified in the BDS of the total quoted bid price after evaluating and excluding GST. In such a case, the bidder shall be required to furnish additional performance security pursuant to so and so. Then 38.1 will come along. Having compared the evaluated cost price of bids as per ITB 34 and applying the provisions of ITB 35, the employer shall determine the most advantageous bid. It does not say that the lowest bidder will automatically be entitled to be to get the contract, my lord. The most advantageous bid, alternatively referred to as L1 bid. The most advantageous bid is the bid of the bidder, also referred to successful bidder, who meets the specification required as per section 2 and section 3, and whose bid has been determined to have been lowest evaluated price cost subject to ITB 35. Now, after his bid was found to be, my lord, page 262. I'll again trouble my lord, page 262, my lord.
262 we have seen.
Yes, he was given an opportunity to justify his abnormally low quoted bid, my lord. And that was rejected. May I read, my lord? MS Kashmiri Lal Construction Private Limited has quoted minus 30.63% below the tender amount and is minus 24.80% below the minimum justified amount calculated by memorandum number so and so, so and so. The abnormally low rate quoted by MS Kashmiri Lal Construction raises material concern as to the capability to perform the contract as per the offered price, and hence ITBP, as per ITBP 36.2, the bidder was asked to submit their written clarification and justification on abnormally low rate quoted by this office letter number so and so, dated 17/1/2023. My lord, it's of January, my lord.
Yes.
We have said, as per the memorandum, we have calculated it's very abnormally low, my lord. The clarification of MS Kashmiri Lal Construction was number so and so, dated 267, this is of 13 February 2024. 13 February, long back, my lord. His bid was rejected, intimated. Now, my lord, I have thereafter, after his bid was rejected, the government has already entered into agreement with the respondent, private respondent. On this is on 21st of March 2024. Already contract. His rejection was in the on 13th of February 2024. Thereafter, agreement has been drawn with the successful bidder on 21 March 2024. Today is approaching this honorable court. His contention, basic contention is that the memorandum of 18 September 2024, 2023 is a part of SBD. This was not intimated to us. That itself is incorrect. That is not a condition, additional condition we have put in the SBD. That is for us to determine.
Your agreement itself is defective.
I don't know. These are formatted agreement with, by the departments.
Work has not been started, my lord.
Agreement has already been drawn, my lord.
Then why, my lord, in Upper Siang district, my lord, they have intimated to the bidders, my lord. Page 282, my lord. They have intimated to the bidders, my lord.
Let me complete.
Yes, sir.
Why they have intimated? It's not the question we'll ask.
Now, therefore, my lord, the citation relied by my learned friend, it talks about a contract between parties. Any addition, substitution to the terms and condition of the contract, my lord. But this is there is no contract till now, my lord. My lord, now, therefore, my lord, the Honorable Supreme Court's judgment in Tata Motors, my lord. I'll take my lord to paragraph 52 and last page, my lord. Paragraph 53, 54, my lord. The law relating to the paragraph 53, 54, 52, 54, my lord. Even 48, my lord. I'll start from paragraph 48, 52, and 53.
We've been reading it for
Because
quite a long time.
just making out a legal point that this was not furnished to us, this was not made known to us, that will not do. And now it is for the greater public interest, my lord. Larger public interest has to be look into than the private interest, my lord. Agreement also has been drawn already. His rejection was on 13th of February. He is coming today, my lord. My lord, therefore, notice may be issued at this stage, but no stay, my lord.
Okay, take a break and come back. We'll have fast orders in chambers.
Always.
Examine fast orders in chambers. Yes.
my lord. AP code volume 1, my lord.
Pardon me?
AP code.
AFR, yes.
Yes, sir. Volume 1.
What's it, AFR?
Regular. Regulation 44, my lord.
Yes.
Subclause 3, my lord.
Section
Regulation 44, my lord.
44.
Yes, my lord.
Yeah. Yes.
Now, what is my submission is that, my lord, they have not delivered a decision. They have only communicated. This is a report which communicate to the EAC. My lord. Now, my lord, see, my lord, order of EAC, page 34. Page 34, the EAC has directed to convene a meeting, committee. Page 34, 4 October 2018. EAC has directed to convene a Kabang, local Kabang. No. Now, in the page 36, my lord, they have not passed any decision. Basing on their, my lord, observation, my lord, and conclusion, my lord, they have submitted the report to the EAC, my lord. Page 36, my lord. This is my last concern. EAC has directed to convene Keva. They have submitted the report to the EAC. There is no decision, my lord. If at all there would have been a decision, I would have some remedy to prefer appeal against that decision, my lord. This is a report submitted to the EAC. EAC directed to convene Keva. They have again communicated to the EAC the report, my lord.
You know, in a lighter note, you've seen orders passed by the Supreme Court of India and SLP admitting SLP or dismissing SLP.
Right.
You've seen?
Yes, my lord.
Okay. No, I'm not commenting. I'm just saying in a lighter note, you said.
Yes, my lord.
If you see, that is good. I can comment there. Yes.
Yes, your lordships, yeah, again, I will refer to section 44, which he had referred. Here, he had only read section 3, but subsection 2 says the deputy commissioner or an assistant commissioner may direct a PKS authority to report their proceedings. To report their proceedings in any case or class of cases in any way which may appear to him to be sustainable, save is required by such direction. No record of any proceedings shall be maintained. That means that can be a verbal decision, pronouncement. If required, then they can sort for a report. Based on this only, the report was
Yes.
given to the extra assistant commissioner. And section 45 further says that unless any party having a right of appeal against a decision of a bill And moreover, if he wants to appeal also, it's on that appeal report that can be considered as a judgment. And he can appeal against that in the proper forum, because even in this Assam Frontier regulation also there is a provisions for appeal. Even in the civil code also there is a provisions for appeal. He can file appeal if he is not pleased with the judgment passed by the village authority. And that too, he is coming in writ after 7 years. It was passed in 2018.
I reserve my reply. I reserve my reply.
Because only to counter that limitation part, because limitation specific time is given, described in that Assam Frontier and the civil, within which period appeal has to be filed. Just to go with that, he came in and read.
This oral judgment, these are very dangerous matters. How to ascertain the right of the parties? How to prefer appeal against the oral judgment without any written form? Now, my lord, what I say, my lord, what I am projecting my case is, my lord, there should be specific judgment, specific decision against which I will prefer appeal. There is no specific decision, my lord. Now, my lord, delay, my lord. Not aware, my lord, this decision, my lord. Kabang report, my lord. This report. Now, what happened, my lord? I have filed an application, page 35 my lord, of my writ petition, my lord. I have made an application before the extra assistant commissioner, my lord, for change of the chairman, my lord. Who is the GB, my lord? Now, my lord, without our my lord, presence, my lord, they have passed a they have prepared a Kaba report. Now, what happened, my lord? We were unaware, my lord. Again, we made a communication, my lord, on 1/11/2018, page 40, my lord, before the EAC, my lord, for change of the chairman of the committee, my lord. Page 40 is there, my lord. Then, my lord, at page 42, my lord, we have filed a complaint, my lord, before the EAC, my lord, on 5 October 2020, my lord, that some encroachment is going on in our land, my lord. Now, basing on that, my lord, this EAC, my lord, has passed the order, my lord, whereby it has been stated that the dispute between the parties has already been settled by the authority, my lord. Page 45 is the type copy, my lord. 45, my lord. May I read, my lord? After receiving this order, we came to know about this village, this report, my lord, Kaba report. Whereas on receipt of a complaint on 15 October 2020 from Sri Solanki, Bangla Dohid district, Teju, to the effect that Srimati Bakinglu Manu with her so-and-so of Manung village has encroached upon his land at Manung village. And whereas, in view of maintaining peace and tranquility and status quo, the then landed EAC cum executive magistrate Wako so-and-so has passed a prohibitive order so-and-so. And whereas on receipt of clarification regarding the complaint along with village committee report from Bakulu Mayu and Miss so-and-so on 14 October 2020, and letter received from Sri Solinkri of Dangla village, Teju along with relevant document have been forwarded to the OC so-and-so for inquiry investigation to find out the actual owner of the land so-and-so. And whereas an inquiry report was ordered and reports received from the OCPS Wakro by his letter dated so-and-so, during his inquiry, it has been found that the case had already been disposed of by the village committee headed by Sri so-and-so, so-and-so. The complaint of Sri Solinkri is not appropriate to be taken up at this office in the light of government order number so-and-so dated so-and-so, 28 April 2011, after establishment of civil courts and contemplating amendments of so-and-so, so-and-so. The complaint is hereby disposed of. However, the parties are at liberty to approach appropriate forum court order. So we only came to know about this Kabang report, Malot, on 4 March 2021, Malot. So we were unaware of this fact, this report, Malot. Because we have been submitting complaint before the EAC for replacing the chairman Malad, of the Kabang. Malad. Now behind our back, Malad, they have passed this Kabang report. Malad.
May I please, Your Lordship? My parent was 1 and 2. Your Lordship may kindly peruse the annexure 5 of the petitioner's petition, Your Lordship. Annexure 5.
Page.
This report has been made. And according to the EAC has taken the action. They were well aware of the report. Because they had participated in the Kabang.
It is true, Malad, we have participated.
And in regard to the EAC's jurisdiction, Your Lordship, they have been writing to the EAC on Your Lordship. The letters for changing of the chairman or the complaint, the basic the complaint which from which the Kabang has been, Your Lordship, conducted. That complaint, initial complaint was also made to the EAC only. Your Lordship. After that only the EAC has done the procedure.
Yeah, I'm not following you. Yes,
Yes, sir.
I'm not following you.
Your Lordship, as like the petitioner's counsel, he have submitted before that EAC does not have the jurisdiction in this case, Your Lordship. But they, according to their petition, Your Lordship, if we can see that from annexure 1 to the annexure 7, Your Lordship, they have been making.
No, Mr. Pijak never said that the EAC had no power.
Yes,
He's not questioning the power of EAC. Have you said it?
No, Malad.
yes, Lord.
Malad,
Not
EAC has convened, Malad, has directed for conducting local Kabang, Malad.
challenging
They have
the power of
again
EAC.
reported, it is an internal communication between the Kabang, so-called Kabang.
He have submitted before, not in the petition.
No, no. You challenge that.
In any way, Lordship, this is the land matter, Lordship, they can go for the title survey in the appropriate forum.
Okay.
According to annexure 7 of the petitioner's petition, also, Your Lordship,
7 is page.
page 45, Your Lordship.
Yes.
The last second, no, the last paragraph, the last second paragraph. The complaint of Shri Solanki is not appropriate to be taken up at this office in light of government order. Notification number, this one, Your Lordship, dated Itanagar, 28 April 2011, after establishment of civil. According to this notification, Your Lordship, we the DPK have no power to adjudicate the civil cases, Your Lordship. The notification is here, Your Lordship. If Your Lordship may like to pay. According to this notification, Your Lordship, if I may, Your Lordship, in partial modification of the government notification, the Governor of Arunachal Pradesh is pleased to order that except DC of Keju, Nupia, and Capital, all DCs being vested with the powers to administer civil justice under the Assam Frontier Administration of Justice Regulation 1945 shall continue to take up cases wherever specific directions are issued by the. This is a notification dated 28 April 2011. And this case pertains to the DC Logi district.
Okay. Well, Mr. DP, sir, I mean, counsel for the petitioner. For the petitioner, Ms.
Sangeeta.
Lisa P. Sangeeta, Leonard, Government Advocate appearing for respondent number 1 and 2. And Mr. D.K. Deori. Yes, D.K. Leonard Council appearing for respondent numbers 3 to
11.
11. By filing this writ petition under Article 226 of the Constitution of India, the petitioner is assailed the Kebang report dated 8/11/2018. And the consequential, as well as the order dated 4/3/2021, passed by the learned EAC, Executive Magistrate, Wakro, WAKRO, Lohit District. First of the petitioners, all petitioners are the petitioner is also seeking for a direction upon the respondent authorities to act upon the complaint filed by the petitioner on 15/10/2018, 1/11/2018, and 5/10/2020. Next one. The case of the petitioner, in brief, is that his land was being encroached by the private respondent numbers 3 to 11. Accordingly, the petitioner had filed a complaint before the complaint dated 25/9/2018 before the village authority constituted under the Assam Frontier within bracket Administration of Justice bracket close Regulation 1945 within bracket hereinafter referred to as 1945 AFR 1945, bracket closed, as well as before the extra assistant commissioner, Wakro, district Lohit. Full stop. The extra assistant commissioner, Lohit district, by an order dated 4/10/2018, constituted a Kebang consisting of a chairman and two members whose names are reflected in the said order. Full stop. Not comma, to conduct a local kabang on 28/10/2018 to settle the case amicably and submit the kabang report to him. Full stop. Next paragraph. The petitioner projects that as the chairman of the Kebang so constituted was a close relative of the encroachers, comma, he had filed an application dated 15/10/2018 for changing the chairman of the Kebang. Full stop. The said prayer of the petitioner and two others was not acted upon However, the chairman of the Kebang submitted a Kebang report dated 8/11/2018 to the EAC, Lohit district, Wakro, informing that the claim of the petitioner and two others was baseless and that the complainants had surrendered that they would not claim again in future Full stop. Next paragraph. The petitioner again filed an application dated 1/11/2018 for change of chairman of Kebang, which was not acted upon. Full stop. However, after fresh enforcement by the private respondents, the petitioner had submitted another complaint on 5/10/2020. And in this regard, the EAC cum executive magistrate from Lower District from Vakro, by order dated 4/3/2021, disposed of the said complaint on the ground that the dispute between the parties have already been disposed of via village Kebang. Poster. Next paragraph. The learned counsel for the petitioner has stated that the Kebang was required to pass the speaking order in respect of the said dispute. But in the present case in hand, the Kebang had merely submitted a report dated 8/11/2018 to the EAC cum executive magistrate, Lower District, Vakro, WAKRO, which cannot be said to be a decision in any manner whatsoever. Full stop. So it is submitted that the cause of delay in approaching this court was only on account of the fact that the Kebang decision was never communicated to him. And it is only when the EAC cum executive magistrate, Lower District, had passed the order dated 4/3/2021, did the petitioners that the petitioner came to know about the decision taken, about the report submitted by the Kebang, and therefore the challenge would be made only after such disclosure. Next, the learned counsel for the petitioner has also submitted that as the Kebang report dated 8/11/2018 is non-speaking and does not disclose the evidence and basis on which such a report was authored. It was submitted that it was a fit case for setting aside the said Kebang report and the matter be adjudicated afresh. In support of the submissions, the learned counsel for the petitioner has placed reliance on the provisions of section 44(3), within 44 within bracket 3, of the AFR from 1945, and has also placed reliance on the Gotcha. No. It's okay, only that much. Next one. The learned government advocate has submitted that the extra assistant commissioner from executive magistrate, Lower district had the power and authority to constitute a committee to conduct the local Kaban. And therefore, in terms of order dated 4/10/2018, issued by the said authority, the submission of the Kaban report to the extra assistant commissioner was fully justified. Next paragraph. The learned counsel for the private respondents has submitted that the writ petition has been filed only to overcome the bar of limitation prescribed under the AFR 1945 for filing an appeal against the Kaban decision. Stop. By referring to the provisions of section 44 within bracket 2 of the AFR 1945, committee submitted that the Kaban is not required to maintain any record of any proceedings. And under subsection 3 of section 44, the Kaban decision can be pronounced immediately after hearing both the parties and witnesses. So it is also something that there are provisions for filing an appeal under section 46 of the AFR 1945, and appeal can also be otherwise maintainable under the Arunachal Pradesh Civil Courts Act from 2021. Next one. Upon perusal of the materials available on record, specifically the Kiran report, dated 8/11/2018. On the court is of the considered opinion that notwithstanding that the nomenclature of the said writing dated 8/11/2018 is in form of a Kemang report. Nonetheless, from the contents of the said report, there is no ambiguity that the said report is the conclusion of the said Kemang, and therefore, it is nothing but a decision of the Kemang. As it was decided in the said Kemang meeting that the claim made by 3 persons, including the petitioner, was baseless. It is mentioned in the said Kemang decision dated 8/11/2018 that the two the complainant -2 KRI members had surrendered that they will not claim again in future. Also indicates that at least 2 of the three members were present in the Kemang meeting.
But we were not present on 28/10/2018, my lord. Like, during the Kemang proceeding of 28/10/2018, we walked away, my lord.
I don't know, I'm reading page 13.
Page 16, my lord.
I'm reading page 39, that is the report.
We have not appeared, my lord. We walked out on the proceeding of 28/10/2018, my lord. Kemang proceeding, my lord. We work. we
I
worked
think
out.
that is written here at page 39. I am reading that only. Next column. We also find from the mandate of the order dated 4/10/2018, passed by the Extra Assistant Commissioner, Lohit District, that while constituting the committee to hold a local command, the committee members were directed to conduct the local kabang on 28/10/2018 at 11:00 hours at Tamla TAMLA dash capital D small u hall, Meadow, MEDO, to settle the case amicably and submit a kabang report to the to him. Therefore, the submission of the decision by the kabang in form of a report is found to be in terms of the mandate given by order dated 4/10/2018. Next, therefore, as again the first one. Therefore, if the petitioner has assumed the said report not to be a command decision, the petitioner has done so at his own risk. Next one. As the provision for appeal is provided for, provision for appeal against the command decision is provided for under the AFR, 1945, and also under the Arunachal Pradesh Civil Courts Act, 2021. If there being alternative remedy prescribed, the petition would not be maintainable. Next time. In this regard, the court is inclined to record to refer to the order dated 7/2022, where the learned senior government advocate had raised the objection about maintainability of the rate petition. According to the preliminary issue, preliminary objection raised is answered in affirmative by holding that the rate petition is not maintainable in view of the alternative remedy available to the petitioner to assail the command decision. Just before that, the one decision that I stated earlier, the previous earlier. You also there's nothing in the petition from which it can be gathered that the the demand constituted by the EAC, Lohit district by order dated 8/11/2018 did not take up the hearing of the case in a manner prescribed under section 44 within bracket 1 of the EFR, 2015. And there's a specific provision under section 44 within bracket 2 of the AFR, 2015 that no record of any proceeding is required to be maintained. The court is of the considered opinion that there is no form of under which a Tabang decision is required to be pronounced. And therefore, notwithstanding that the decision in the present Tabang is under the nomenclature of Tabang report, yet the decision of the Tabang, though in form of a report, has to be considered to be a final verdict of the said Tabang. Thereafter, this other two paragraphs with them. Okay.
My lord, I have one prayer. I am before this honorable court with a question of substantial question of law, whether the report is a decision or not, my lord. Now, my lord, the facts, my lord, may be kept open because this is a disputed question of fact, which I have to project before the trial court, the appellate court, my lord. If it is determined here, it would affect me, my lord. The facts, my lord. I am only on the law point, whether the report, the internal communication, well, this report, my lord, is a decision, my lord, is an order, my lord.
No, you have not said anything about the decision itself.
Yes, my lord.
Did I say anything?
My lord, on that, my lord, I have surrendered my so and so, my lord.
No, that is a part of the record. You can't change that record.
My lord.
I'm not saying something which
We are, my lord, disputing this fact.
No. No part of the order is an original adjudication. In the order which I have just now authored, no part of this is the finding of the court. I didn't record that this is my finding. You are only saying that this has happened. So take back your.
But we may be given liberty to approach appropriate forum, my lord. A direction, my lord. At least, my lord. A direction may be given, my lord. Parties may approach appropriate forum.
No, because we have not entered in the petition.
My lord.
So there is no requirement of giving you a liberty. Alternative remedy is available and therefore we have dismissed it. So what does it mean?
Indirectly, if it is reflected,
No,
my
no.
lord.
You see, there is another thing. If I give that liberty, then you say that the High Court has given us liberty, therefore condone the delay.
No, no, no.
Obliged.
Obliged.
Or some date could be fixed. That's the only thing. Otherwise, Justice Nayak cannot fix a date. My lord, if 17th June.
No, but urgency was expressed, so I have to continue to hear you.
What to do, my lord?
No, I don't know.
Sometimes, my lord, strange things happen in the court. That's it. Matter was heard. It was the second day. On second day, counsel wrote something on paper and gave it to Justice Nayak. Justice Nayak says he doesn't remember it. But then that's it. Sometimes people do things in a peculiar fashion. Because my lord's hands are full, otherwise even tomorrow I am here, but I don't think if it is possible. If it is possible, my lord, even tomorrow I can argue. Need be day after tomorrow, I can continue. Because it's all there. It's very, very old case. All kinds of efforts are being made. And now standing counsel, now I'm being told. It's very funny. Today, the Honorable Court was informed that even the standing counsel is not there. Not there means today only standing counsel informs the court that he has ceased to become the standing counsel. Department has released him. Now, not on 2nd of June, counting will be done. New government will be formed. At this stage, removing a counsel by the department, I'm quite astonished. Matter was heard. Today was the second day.
No, this is regards, I think this is
Intersessionality dispute between direct recruit and promotees.
So how elections you are referring to?
No, the Department of Urban Development and Housing is a concerned department. Today is the second day of the case, and the London Council informs the Honorable Court that he has ceased to become the standing counsel. He has been removed by the department. In that context, I said, on 2nd of June, a new government will be formed. Normally, these things do not happen. One would expect council will continue till at least the 2nd of June or 3rd of June or 4th of June. It is as if, because too much of coincidence becomes part of the, normally the saying goes in English, on first occasion it may be a coincidence. On second occasion, well, one may even consider it to be a coincidence, but then the way things are happening in this case, because if I continue with your lordship also in this case tomorrow, the plea will be that the council is not there of the department. So I would presume, let it be 17th of June. Because difficulty with Justice Nair is now he can't even pass any order. He can't even fix a date. After the kind of Honorable Court was not informed yesterday about that. It is when the wind started sailing and the direction of the wind was seen, then
And the problem is this order again, once the court says you express urgency in the matter.
I beg your pardon, my lord?
The court has recorded that you have expressed urgency in the matter.
Urgency, yes, because it's very, very old case. So because my lord, it was continuing since yesterday. So I thought I'll be able to finish it. All of a sudden I was taken aback. So again, lordship may record my submission because I understand my lord's difficulty also. Lordship cannot. And now on top of it, they say the department has changed the council. Department now, the council is no longer the council of the department.
No, that's okay. You get a walkover.
I can still argue, but I can continue tomorrow if my lord is, I subject to your lordship's convenience. If I can finish it, I'll finish it. If my write-up is there, everything is ready. I'll just present my write-up, nothing else. Tomorrow I am here, day after tomorrow I am here. 2 days, if need be, I'll remain here for 2 days more. And can finish it
Day after tomorrow then.
Very well.
If you're there.
I'll take a short time. Since my write-ups are there. They may leave, I'll complete my part. It will be parted before the lordship. Because there is no guarantee. He's informing me that other councils may leave. They will not be present day after tomorrow also. I don't know.
No, I don't know, but parted I'm not keeping from this
Then
bench.
let it be 17th June if that be the case.
Because there's a lot of,
17th of June, I was told the bench of Justice Soumitra Shekhia is there. Hopefully I'll be able to finish it. Because 3 days I intend to remain, 17th, 18th, 19th, if I can finish this case during those days.
no, because if it is likely to be over, then I can take it up. If it's not
I
likely
can
to be
finish
over.
my part, Lord. I'll not take more than 1 hour.
Who's for the other side? You're for
My lord, I am for the respondent note 4 and 5.
4,
4 and 5.
4 and 5. How much time will take?
My lord, conducting counsel is Mr. D. Phangin, my lord.
No, I'm not concerned with who is the arguing counsel.
Good only.
Once you are there with the brief, you tell us how much time
My
you
lord,
take.
Mr. Dicky Panging, 4 and 5, my lord, I am not seeking any relief against them. I have made it clear to Mr. Dicky Panging. He is the lawyer. So in fact, he was waiting.
I'm just managing my time. Now, he may not have anything, but he may still argue. We don't.
No, that he knows it. He will not argue also. In fact, I told him. He knows about it. I had talks with Mr. Dicky Panging.
Who is for?
So 4 and 5 has no role.
Who is for others?
My lord, I'm for respondent number 10, 11, and 12.
Please button up your coat first. Button up your coat first. Don't keep it open. Yes.
My lord, I'm for respondent number 10, 11, and 12.
Yes. How much time will take?
My lord, my senior counsel, he will be absent in this next week. Therefore, it will be better in 17th of June.
Okay, then. Okay, all sides except the Urban Development and Housing Department are represented. The as the learned senior counsel for the petitioners had expressed urgency in the matter. The matter was listed. The matter has been listed today. Poster. The learned counsel for respondent numbers. Yes, respondent numbers. Respondent numbers.
10, 11, and 12.
10, 11, and 12.
Yes.
No, it can't be 10, 11, and 12 because somebody is appearing for 8 to 10. Somebody is appearing for 13, 14. 13, 14 is Mr. Tara.
Tara is for Mr. T. Tara is for 13 and 14. Okay. You not been informed them, otherwise
No,
they will not be here.
Since I'm writing his adjournment, he is appearing for whom? I must record it. So you don't know.
Who's your senior? Huh?
Rajesh.
Rajesh किसके लिए है?
Rajesh. What is the name? Your senior's name?
Rajesh
Mr.
Sonar.
Rajesh Sonar.
Mr. Sonar.
Yes.
Sonar is for 8 to 10.
Lord, I don't know. Who's appearing for who?
For respond 8 to 10.
यहाँ पर थोड़ी लिखा है. Lawyer's name you will not.
The hearing is likely to take some time, and the conducting counsel will be on leave in the next week. According to the matters adjourned today, reluctantly adjourned today, as this is a repetition of the year 2015, and therefore 8 years old. Next paragraph is agreed to by the senior counsel for the petitioner and the whether respondent counsel is present. List on
17th June.
17/6/2024.
Actually, my lord, this case was heard last week. So it was carried over as part heard. And today also it was heard. The moment the direction became clear, then
Unfortunate.
these things do happen sometimes. What to say?